All right, you guys are all set.
That was crazy.
I think it's David's thing. All right, is it 7? All right, 7 o'clock. Perfect. All right, I will call to order the Zoning Board of Appeals meeting for Wednesday, October 26, 2022. To all persons interested in or affected by the actions of the Zoning Board of Appeals, you are hereby notified pursuant to Section 11 of Chapter 48 of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing on the following appeals will be held on Wednesday, October 26th at the times indicated. The Zoning Board of Appeals public hearing will be held by remote participation methods. Public access to this meeting shall be provided by the following manner. The meeting will be televised via channel 18 and may be viewed via the channel 18 website at http://streaming85.townofbarnstable.us/cablecast public site. Real-time access to the Zoning Board of Appeals meeting is available by utilizing the Zoom link or telephone number and meeting ID provided below. Public comment can be addressed to the Zoning Board of Appeals by utilizing the Zoom link or telephone number. The link is https://townofbarnstable-us.zoom.us/j/870-353-38923 or calling the number 888-475-4499 and entering the meeting ID 870-3533-8923. Applicants, their representatives, and individuals required or entitled to appear before the Zoning Board of Appeals may appear remotely and may participate through accessing the link or telephone number provided above. Documentary exhibits and or visual presentations should be submitted in advance of the meeting to anna.brigham@town.barnstable.ma.us so that they may be displayed for remote public access viewing. Copies of the applications are available for review by calling 508-362-4682 or by emailing anna.brigham@town.barnstable.ma.us. So I will start by introducing board members. I'm Jacob Dewey. Herb Bodenseek.
I'm present.
Is here. Paul Bernard.
Present.
Todd Volantis. Todd is absent. Mark Hansen.
Present.
Aaron Webb.
Present.
And Denise Johnson.
Present.
All right. Please note that this meeting is recorded and broadcast on Channel 18 in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone is taping this meeting, and please make their presence known. All right. Seeing none. Minutes. We do not have any minutes to approve tonight. I believe we've got some minutes being worked on. Our council liaison, Councilor Clark, had mentioned that there's some minutes we're getting caught up on, and we will get them caught up and published on our website as soon as possible. All right, so our first item is a discussion and vote. Request for minor modification of Katuitt Residences Comprehensive Permit number 2005-100 in accordance in 2007 Comprehensive Permit number 2005-100 was granted for 5 units of multifamily housing on 2.38 acres in a letter dated August 26, 2022. Attorney Patrick Nickerson, representing the Condo Association, requested a minor modification of Comprehensive Permit number 2005-100 so that the responsibility for maintenance of the existing landscape is transferred from the town to the trust, and so that the trust may make changes and improvements to the landscape and its aesthetics. By permitting this minor modification to the comprehensive permit, the trust will be empowered to make changes, improvements, and maintenance to the landscaping aesthetics. The town will also be relieved of its obligation to maintain the existing landscape. I believe Attorney Kenny is here for this.
Good evening, Mr. Dewey.
Oh,
My name is
Mr.
Patrick Nickerson, and I'll be handling this matter.
Okay.
May it
I
please the-
guess I need to assign, I guess we'll assign members to this. So our regular members, myself, Herb, Mark, and Aaron, you are now a regular member. So it would be, oh, sorry, and Paul, you're here too. And Paul. Go ahead, Attorney Nickerson.
Thank you, Mr. Chairman. Also present with me, but is not on video, are Denise Moynihan and Molly Kelly. Denise is the current president of the trust, and Molly Kelly is serving as the treasurer. They are here with me in the room, but they are off camera. May it please the board, our request is to revert the town control over maintenance of the existing landscape and allow the trustees to make changes thereto. This parcel has somewhat of a lengthy history. After the comprehensive permit was approved in 2007, it became subject to an endorsed disposition settlement agreement 3 years later, and then in 2013 became subject to a memorandum of understanding. Those two subsequent documents placed some additional controls on the parcel and limited the trust's ability to maintain its own landscaping and make changes to it. In 2018, the trust did submit a master deed. The master deed does allow the trust to maintain, repair, replace, and alter the landscaping. We're requesting that this board find that our request is a minor modification and approve the relief that we've requested as stated by the chairman and as set forth in our letter. I'm happy to answer any questions you may have. Thank you.
All right. Do any of our board members have any questions for Attorney Nickerson?
Yeah, this is Paul. We previously had this case in the near past, and I'm wondering, and it was for a specific relief rather than a blanket relief. And so I'm wondering, has any work been done between then and now?
To answer your question, I'm not aware of any. Perhaps Mr. Florence might be able to answer that specifically, but my understanding is that when conversations were had between the trust and Mr. Florence, and that the trustees became aware of a potential issue with the previous decision, that they immediately sought our assistance to resolve it. And we are not here making any specific proposals for changes related to the parcel, just to essentially allow the trust to maintain the landscape and make changes in pursuant to its own master deed and bylaws.
Well, yeah, I mean, I understand that, but they asked for specific relief to do specific things the last time I was here, and my question is, were those specific things done? Yes or no?
Attorney Nickerson, it we involve completing a retaining wall or fence in the rear of the property, completion of plantings in the front of each condo building, and beautification around the catch basin rain garden.
Yes, President Moynihan and Treasurer Joyce are nodding that those projects were completed.
Commissioner Florence, did you want to add to that?
Sure. Thank you, Mr. Chairman, members of the Zoning Board of Appeals. My name is Brian Florence. I'm your building commissioner. Yeah, that work was done, Paul. When they made application for that permit, it was our understanding that they were going to make this blanket request. The blanket request is before you now. The reason for it is that memorandum of understanding was intended, it was never intended to be a permanent device. It was always meant to last just until the building permit, the certificates of occupancies were issued. Unfortunately, that's not the way it read. And so when the current president came to us for a building permit, we suggested they ask for a modification to the special permit, a minor modification, and get it on the record that they were supposed to do that. And in fact, the board talked about that, but they never codified it, and they never made it part of the decision, and the applicants never actually asked for it. Subsequently, they came for additional repairs, and I found them having to have the same issue. So that's why they're here tonight. It's no other project like this, the 40B projects or anything like that, have the town responsible for the maintenance of their property. It was just an oversight in the MOU, and this is to correct that. Thank you.
Yeah, Mr. Chairman, yeah, the basis of my question is that based upon our previous approval, they have performed per what we agreed to. And so so therefore I don't perceive any problem with, I mean, the track record speaks for itself. And so I would support the current applicant.
All right. Does any other board members have any questions or comments?
I'll actually ask the question I was going to ask. So thank you.
All right. So I will open for public comment. Is anyone here to speak from the public on this?
I don't believe so. It might be though.
Okay. Anna, we didn't receive anything, correct?
No, Mr. Chairman, this is not a public session, so and notice that we need to
I mean, I don't see any problem with it as long as we have the authority to make a minor modification without any, legal ads or anything else. I mean, and has that sort of been clear that we can make this modification?
Yes. It's just a discussion.
Someone does have their hand up. It says iPad. It might be somebody for public comment. I'm not sure who it is.
Okay, person that's iPad, did you want to speak in this discussion? Okay. All right, I will make a motion that we approve the minor modification to empower the condo association, minor modification to comprehensive permit number 2005-100 to, I guess, empower the condo association to have the responsibility for maintenance of the existing landscape. And it's transferred from the town trust to the condos association trust, to them to be responsible for landscaping and its aesthetics. Is that acceptable, Attorney Nickerson?
Mr. Chair, there has to be two.
So I'll make a motion that we find this request for the modification to the landscape maintenance plan as a minor modification. Do I have a second?
Yeah.
All right, and a roll call vote on that this is a minor modification. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Mark Hanson.
In favor.
And Aaron Webb.
In favor.
And I am also in favor. So we've determined that it is a minor modification. And now I will make a second motion to approve the request for the modification that will transfer maintenance of the existing landscape from the town to the trust, as discussed. I need a second.
Yeah, this is Paul.
And a roll call vote. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
And I am also in favor. So Attorney Nickerson, you guys are all set.
Thank you very much.
Thank you. All right, moving on to new business. In appeal number 2022-049, Richard Sunderland, Samantha Gray, and Damian Murray have filed an appeal of an administrative official's decision in accordance with section 240-125B1A. The building commissioner issued a notice of zoning violation in order to cease and desist on August 25th, 2022, which stated that pre-existing non-conforming auto body shop has expanded in scope, size, and volume in violation of section 240-94B. There has been an expansion of a pre-existing business and parking area without site plan approval, and the results of the expansion necessitated the redesign and reconfiguration of the pre-existing parking lot and was accomplished without site plan review approval in violation of 240-100C and D. The subject property is located at 970/972 Main Street, West Barnstable, Massachusetts, as shown on Assessor's Map 156, parcel 026. It's located in the WBVB zoning district, which is the West Barnstable Village Business District. Sitting on this, again, will be our regular members, Herb Bodenseek, Paul Pinard, Mark Hanson, Aaron Webb, and myself.
Jake, I have Chuck Sabat up on the name. I just couldn't figure out how to change it in time, so.
No problem. Attorney Lawler, over to you.
Actually, I believe legally, it's the building commissioner's burden to prove the offense before, I think he has to go first legally.
I believe when you are appealing a decision, it goes to you to
It's quasi-criminal on the building. I'm quite certain, I looked at the case law earlier today, and I believe it's the building commissioner's obligation to prove when it's a violation. Brian, do you have any issue with that, or do you have any comment on that?
Mr. Chair, if I may, Kate Connolly, Assistant Town Attorney. I'm here on behalf of the town of Barnstable.
Didn't see that, Kate. I'm sorry, I would have directed it to you.
That's okay, David. I believe that it is, I don't think it's going to make a huge difference either way because we're prepared to do a presentation, but I think it is the person appealing's burden to explain, to at least start initially explaining what the appeal is. This is not a criminal matter. It was in housing court initially, and this is why it's been back to the board because this has gone on for a few years now. It initially was brought as a criminal complaint in housing court, and the parties agreed to dismiss the criminal case in housing court and to allow the applicant, upon receipt of a new notice from a violation from the building commissioner, to file a new appeal. So that's why we're here before the ZBA tonight, is to review this new appeal.
And I was just reading it over about an hour ago, and it said violations. It was Westlaw. It was just violations. I think because it comes with a fine. It's not criminal, but it's quasi because it does come with a monetary fine and can be enforced if later that it is the Commonwealth. So the building inspector's burden to prove that they're an actual violation. I mean, I'm trying to, in essence, trying to prove a negative. And whereas, I think it's the obligation of the building inspector to show that there in fact was a violation of the law. I could look it up in 2 seconds, but I don't know.
That's fine. I mean, if I may, Mr. Chair and members of the Zoning Board of Appeals, as I said, we can go first. I don't know that that's the correct order, but I don't think there's any harm in this case for us to present the building commissioner's reasons for issuing the notice of violation. Basically, it's a pre-existing non-conforming auto body shop that's use has expanded greatly beyond what was previously conducted there. And I think at this point, I would like to defer to Brian Florence, the building commissioner, to explain what he has observed on site visits. And then if there's anyone else who wants to speak in support of the building commissioner, I'll leave that to you, Mr. Chair, as the order in which you want to take it. But certainly we're happy to have Brian speak to why he issued the order, if that's appropriate at this time.
And then I can question Brian after you're done, right?
Sure.
Yeah, I mean, I customarily, when we've had it in an appeal of the building commissioner's decision, the building commissioner has referenced the reason for why he violated, why he made the violation to the appellant, and you've come forward, you've requested this hearing. So generally, we would ask you to speak why you requested this hearing, why you're here.
Well, it's really because that's fine. I'll ask. I want to ask Mr. Florence questions then, specifically to as a hearing to present this as a hearing. That's what this is, and the reality is this: is that I don't believe that I just want to put some things on the record that this is clearly a pre-existing non-conforming use, allowable use as an auto body repair shop. Is that agreed upon?
Yeah, I think we need you to present your position on why you feel his violations are inaccurate.
Okay, I call Brian Florence as a witness.
Mr. Chairman, members of the Zoning Board of Appeals, thank you for your time. I appreciate you again This is not a court case. We have submitted a notice of violation to the applicant. He would like for us to stipulate that there's a pre-existing nonconformity there. Okay, we will stipulate that. There's a lot more to what's going on than that, though. So you're 100% correct, Mr. Chairman. I have never in 25 years seen an appeal of an administrative decision turn into a trial before the zoning board of appeals.
Right.
I've only seen a appeal of an administrative decision where the applicant comes in and says, here's why the building commissioner is wrong. Here's why we think that you should overturn his decision. And that's, at that point, the chairman usually calls on the administrative official to give his side of the story. So I guess I would be happy to make a case, but I'm basically making a case for Mr. Lawler to defend against in front of him. So I think the proper procedure is for this not to be a trial and for Mr. Lawler to make his case and let us go about our business here.
Fair enough.
And yes, Mr. Chairman, if I may again, as Mr. Florence just stated, this is not a trial. It's a much more informal proceeding, and the burden is always on the appellant to explain why they believe that the building commissioner in this case was incorrect. We can then certainly defend, but this is not a matter of cross-examination. It's not a court, it's the zoning board of appeals.
Okay, sorry.
That was my understanding. I just want to ask, any of the board members have any feeling towards one way or the other here?
I'll concede. We'll do it the old-fashioned way. I'll
Okay.
concede.
Right.
So at first, I would like to make a presentation. I just have some people in the room with me that are involved, and I just ask you to introduce yourself. This is Sam.
Sam Jeffrey on.
Neil Atwood.
Damien Murray. Okay, and Damien and Richard are named in the, Richard is the owner of the property and Damien is the operator of the specific business. Now, I've submitted photographs and I know that the town has various photographs. This property has been utilized as a auto body shop since way before the 40s. And to make it easier, the building commissioner, Brian Florence, has stipulated that it is a pre-existing non-conforming use with respect to an auto body repair shop. And that the real issue here is their claim that the expansion of business is in itself a violation of that zoning. Twofold. I want to show, number one, that there really hasn't been an expansion of business over the years. And two, that even if there were, it's not a zoning violation. And I'm going to go directly to that point as we speak. Anna, could you bring up the case law that I provided earlier under Westlaw?
Just one second.
Scroll down to the bottom of page 6. Let's make to the chase. And again, if we were here, if this was in person, I would have provided this. I prepare for these things generally right beforehand, and I would have seen Kate and given her the case law. I put it up on the screen about an hour ago. This is a case I'm referring to as Cape Resorts Hotel, Inc. versus the Alcohol Licensing Board of Falmouth et al. It's called Cape Resorts, but anybody who's over 50 will remember this as the Brothers Four, right across from the casino, one of the finest places used to exist in the 80s.
I am unable. Can you see this? I'm unsharing.
Are you able to help make Anna able to share screen?
I sent the documents.
Oh, no, sorry. I meant David from Channel 18. Sorry.
Oh, I'm sorry.
What do you need me to do? Make him a.
If you can give Anna Brigham permission to share screen.
I did, didn't I?
It says host disabled participants.
And then we'll close caption. Hold on.
David at Channel 18, are you still working on this?
Yeah, give me 1 second.
Okay, no problem.
Do you want me to just read the case law? Is that better? Or you trust me that I provided the document, so it's verification? Do you want to?
I have no problem with you reading it. I mean, I just want to give you the opportunity to have anything you want to display on the screen. I assume you may have the photos displayed as well.
Yeah, I have all that too. But
Let's give David a second and see if he can work on it.
Okay.
And then Anna, did this document get? I don't see it in the Laserfiche. Was it put into public comment or?
It's in laser. He had emailed me various posts.
If you want to
Yeah, I'll just read
with
it.
this part, and if we get the photos, we'll make sure that David
Part of
Channel
the record.
gets this online.
Okay.
So, Attorney Lloyd, before you start, Anna, if it's in the Laserfiche, then we can all pull it up.
Yes,
And what page was this? There's 18.
It's on 6 of 13 on the very bottom, and it's the last paragraph.
Okay, can you give me a second?
Kate doesn't have it.
Okay.
It's the file called Westlaw.
Yeah, I got it, and I got page 6. So you're talking about the last paragraph?
Yeah, it starts with Cape Resorts Reliance.
Yep, okay, I got it. I would wait for a second to see if others can pull it up. Okay, well, I've got it. I don't know. Does anybody else have it? Or
I have it. Aaron, you good?
I have it, yep, and I've read it.
Okay. Go ahead, Attorney Lawler.
Okay, one of the main basis being presented here by the town is that the expansion of business, it's in and of itself.
She should be able to share her screen now. So Anna, can you try that out?
yes.
There we go.
Okay.
And if you look at the last paragraph there, I'm going to read it out loud for you. It says Cape Resorts Reliance. Cape Resort was the party that was being alleged to have violated the zoning by overburdening a pre-existing non-conforming use. On the rule that a mere increase in volume of business done does not constitute a change in use is misplaced. While it is true that a use is not different in kind simply because it's bigger. That's the line that I wanted to focus on. Building Commissioner of Medford versus McGrath, 312-461. Now, I didn't include McGrath, but I want to read to you McGrath. Very short opinion. I should have, I meant to scan it and something happened. The use of the premises, this is McGrath, for a riding school was an existing non-conforming use at the time of the adoption of the zoning ordinance, and hence was unaffected by the ordinance. There was no change in use. There was, so far as appears, no alteration of the building, which is the same in this case. It has been decided that a non-conforming use of the same premises may not only continue, but also increase in volume. And that's the law. I shepherdize it. It's still good law. So the actual the alleged violation in and of itself does not constitute a violation of zoning. You know, it makes sense. Let's think about it. We just went through COVID. What happens all of a sudden if a business that's non-conforming, and there's, you know, hundreds of them probably in the town of Barnstable. I know there's dozens of them. If a business is non-conforming, say a restaurant, for instance, and you have COVID and it lasts a little longer and you're shut down for a couple of years, do you then, because you have increased your business again, now do you no longer conform to zoning? Or you go through a recession, but you're able to make it and your business declines by 50% and then you increase it again by up to where it was. Does that impact and then allow you to say that your nonconformity has been extinguished? No, it does not. The law is clear and simple. Now, that pointed out, I would like to go to the next matter is that we don't even think it's really increased at all. It's changed up and down, but not over a period of time. If you may, Anna, with the photographs, if you could pull the oldest up to, I don't know really what order they're in. I just pull them up and I can go back and forth. Pull that one up. If you scroll up a little bit, unfortunately, you get a little bit of my desk up there. This is a photograph of the premises that was taken probably in the 90s, and you'll see the back area. There's probably, I think we counted 30 some odd cars involved in there. The buildings are identical. I don't know if you can, are you able to pull up more than one photo at once or not?
I don't think so, Attorney Lawler.
Okay, if you can find the one that I sent, which was actually taken today, it's the one with a sunny sky. It's in my.
The 0302 and the 0304, I was not able to open. I don't know if.
Yeah, there was two of them I couldn't open and I resent. Okay, well, this one right here is an aerial of 2014. Again, loaded with cars. Now, the history here is an affidavit that was submitted that's part of the record. We have the gentleman who actually signed the affidavit, and he's going to acknowledge that everything in there is true, but there's more that was not contained in the affidavit because he wasn't asked. But again, if you see that photograph, you'll see the use of it in 2014. Now, Neil, who has run the premises for actually, how long run the premises? 1975. Neil Atwood and that one, right? Yeah, Neil Atwood is here, and I'm going to ask him some questions. But he was running the premises when this was taken, and also when the prior photograph was taken. I don't know. Again, one of the photos that was shown today shows the premises. Unfortunately, it might be one of those ones that I sent that can't open. It says, it's the one that says one of the zeros. No. Again, and this one shows the property, I believe, in 2006. There's a long history. Now, what I wanted to show, and it's not in front of you, is for some reason it was sent, but it shows as zero. They just don't open. You can see them. They don't. I couldn't open them either. I re-emailed them. I don't know if there's any way to get them on. It's probably too late. But those photographs will show that the premises is in a relatively neat and orderly condition. This is another one from 2015. Again, showing the back of the lot with vehicles in it. And Mr. Atwood in his affidavit testified that at all times that he not at all times, but he had up to 3 employees. He works 5.5 days a week. He's also here and willing to testify that, he would also work nights if necessary, whatever it took to get the job done, or Sundays. And what's not contained in the affidavit is that he also loaned the shop out at night and other times to people who would use the shop when he wasn't there, either to paint vehicles or to paint cabinets. This shop has been used consistent as it is today since the 1960s, 70s, 80s. Neil's stepfather ran it before him. It's been in his family. The only thing that's changed since the beginning of the 70s, his ownership changed in 2019. Neil Atwood, Demetrius, Damian Murray, I apologize. Damian Murray. And granted, when Neil retired in December of 2018, January 2019, he slowed down, cleared out the property and changed, but continued to operate. Neil, could you say, what your operation was throughout the entire time? Was it similar to what it is today?
Yeah, it's very similar. We just basically had to do what we had to do, and that's it. It just, we worked when we had to work, and Sundays, nights, Saturdays.
And would you leave the doors open in the summertime?
Yes, doors are open, worked outside.
Is that for ventilation and for
ventilation and comfort?
It's too hot?
Too hot.
Okay. Would you even leave them open in the winter sometimes?
To get cars in and out, yeah, that's all.
Okay.
And the greenheads would bite in the summertime.
And when the greenheads are biting in the summertime. How old are you now?
78.
Okay. So, and you did the business for how many years?
50 years.
50 years. Okay. And with respect to, and you've seen some of the allegations that have been made against Mr. Murray, isn't that correct?
That's correct.
And have you been by the property since it's been under new ownership?
Yes.
How often?
Maybe once a month I drive by there.
You ever go in and see Rick and walk by and see the property?
Yep.
Okay.
And it looks basically the same
As
when I had it.
Okay. Now there was some talk about, cookouts at night and other things like that. Can you tell me a little bit about the hot rods?
Yeah. Some roads have old classic hot rods and classic cars.
What about Thursday nights?
And Thursday night was a designated meeting night for all those sells the Shark City lug nuts.
And how long did the Shark City lug nuts meet at your shop on Thursday nights?
Up until I was gone.
But how many years probably?
Oh, 20 years probably.
Okay. And you used to play music out as well, isn't that right?
Yes, we did.
And did you ever get a complaint from the neighbors?
No.
Okay.
They welcomed us.
They welcomed you. Okay. And the activity today is the same as the activity before?
Yep.
And when the business would change, it would go, you'd have certain times that were busy and certain times that weren't busy. Is that right?
That's correct.
Okay, over the years.
Over the years, yeah.
Okay. And would it change with the economy and recessions and things like that?
It did change,
Okay. And get slower and then
it gets
busier?
slower, and then it would pick up again.
Okay. And that's all. And then I just want to ask Rick, have you been involved in the business?
Yeah, I worked there in the 90s.
Okay. And you own the property now?
Yeah.
When did you buy the property?
Not good with timeline. I haven't thought of it about 8-9 years ago.
Okay. But you lived close to, have you lived in that area your entire life?
64 years I've lived within a few miles.
And then,
oh, I'm sorry.
And then you lived within a few, okay. And have you observed the property over the years?
Absolutely.
And it's gone.
I was friendly with Hooten, who was the original guy.
He owned it before Neil.
Correct.
Okay.
And, so I'm very familiar with the property, and that's probably why I got involved in it. And the history and whatnot.
And since Damien bought the property and bought the business, what's changed?
He painted the building, cleaned the windows, cleaned the lights. Did a lot of upgrades in the sense of just cleaning up. But the building hasn't changed. The parking area has not changed. Nothing's really changed that I can tell, except maybe since Neil's retirement, he wasn't bringing in new work, although there were other people working there. And I think Damien's doing the amount of work that was done there just prior to.
But that was just for a very short period of time when Neil was
prior to Neil's retirement.
Okay.
Yep.
And now with
That's
respect to, now Sam, could you just tell the board who you are?
I own the property that is directly abutting to it, 990 Route 6A.
And there's a fence that's between the two?
Yeah,
And who put that fence up?
I put up the fence, I want to say 3 years ago.
Okay.
just because I was just upgrading the entire exterior of the property, doing some groundwork and, sprucing it up a little.
And now you've seen the photographs of the vehicles that park, close to the property line or over the property line. How long has that been going on for?
Well, I worked in that unit 4 of that building from 1987 to 1989. They were there then. I mean, there was a common property line that was a little fluid, understanding that good neighbors,
And it's,
work with each other.
and it's remained that way since the early 80s?
It's the same way it was then and it is now.
Have you
And
noticed now, how often are you at the property?
I go there about once a week, sometimes more often, depending on if a tenant has an issue. There's 4 tenants in that building. So, or if I need to do any repairs or whatever.
Okay. And since the change in ownership from Neil to Damien, have you noticed anything?
Well, like Richard said, the place has been cleaned up. The building was painted and it's just neater and cleaner, and I think it makes my property more valuable because it's been up.
And with respect to the vehicles parked there and stored there and the amount of work there, is over the years, is that similar, or what's the difference, or?
No, it's about the same. And I wouldn't say that today is any worse or better. It's about the same, and it's never been a bother. My tenants have never complained about this. I've had 2 tenants that have been there for 30+ years. They don't complain. They didn't complain then. They don't complain now. My new tenants also don't.
Now, and what about the noise?
What noise? I don't hear any noises. I have some gardens out front, so over the summer I'm there a lot. And
So you're actually out there, in the summertime, you're there more than once a week.
oh yeah, because that's where my vegetable garden.
So you're there almost every day watering and,
Yeah, about every other day doing something, and it's not noisy. Yeah, it's just not noisy.
and then, with respect to, and the use there, have you ever seen them selling cars there?
No, no.
There's some accusations of change of use. Mr. Murray, have you been, you own a used car dealership somewhere else, isn't that correct?
Yeah, I partnered up with somebody where we sell cars.
But you're not selling cars in West Barnstable, are you?
No.
Are you doing any other business other than auto body repair? And then, what's the primary hours of operation that you utilize the shop?
It's from 8 to 5. That's the official business hours, but like Neil said, to get the job done, sometimes we'll stay a little bit later. If there's a job supposed to leave the next day and we're behind, I'll stay and put in the extra hours and get it done, so the customer will be happy.
Okay. Now, recently there's been some issues that deal with some noise complaints. Can you tell me what happened when the police arrived?
So the police arrived. They said they've been called so much they start walking up the street just to see if they'll catch us in any act, and they always said there's no violation, there's nothing going on.
So there's no noise complaint.
I also asked them if it do anything, because people keep calling, like, does that affect us in some kind of way? And he said they can't stop people from calling. They each time they just got a notice that there's no violation.
Okay. So you haven't had any noise violations?
No.
But the police have been by on numerous occasions.
Yeah.
Okay, without any violations being issued.
Yep.
Okay. The situation here is, for whatever reason, my client said their own thoughts they're going to keep to themselves, but that this business has not changed since the there are periods when, and I know Mr. Florence is going to show some photos with less cars and more cars and things like that. First of all, based upon the case law that I've submitted, and again, and I referenced the 3 cases for the record: Building Commissioner of Medford versus Earl McGrath, 312 Mass 461. Cochran versus Romer, 287 Mass 500 508. And then the case I submitted, which is the Butters 4 case, actually it's referred to as Cape Resort Hotels. And that is, my glasses, I can't read it.
85 Mass 205.
Thank you. They were on top of my head, Kate. I didn't even know.
I'm looking at it in the list of cases that covers the what's considered an extension or alteration of a pre-existing non-conforming use.
Mhm. And our position is that this has not changed. And I think that what's happened here is that the town has received numerous complaints. I think they're unfounded complaints. It's not different. These folks, it's like moving in next to an airport. The airport's been there. They moved next to the airport and they're complaining about the plane. And that's what's happened here. And this is a valid, well, first of all, it's been acknowledged that the use itself is an auto body repair shop. It's been, that's agreed that that's a pre-existing non-conforming use. The question is, number one, even if, is it expanded, which we suggest it has not been over a period of years. And number two, even if it has, it's irrelevant because that's allowable under the law. I'd like the ability to readdress after.
Yep. All right. Thank you, Attorney Lawler. Let's first just, I'm trying to think what the best way to do this here is. Any board members, do you guys have any questions for Attorney Lawler, or do you guys have them sort of noted down and we can hear from Commissioner Florence first?
That's what I'd like to do if possible.
Yep. Okay, anyone else have any pressing questions at this time for Attorney Lawler before we hear from Commissioner Florence?
Well, her bone's sake, I just, the Samantha Gray and the other person named, they're actually in favor of supporting the building commissioner's decision, correct?
Yeah.
So I'm a little,
I don't know. I think there was a typo or a Scrivener's error that they got transposed on the application, and that's I don't know why they're on there, and that I would move that be stricken. I think that's my fault. I don't know. Whatever,
okay.
we're writing it down. That got put on there, and that's. I thank you for bringing that up, Herb. I forgot. I meant to bring that up right away, and I forgot to. That's
Yeah, we can talk about this later, but you've got 49 people. Certainly all of those 49 people didn't just move in yesterday. But you got 49 people on a petition. So we can talk about that later. So we'll get back to what we were talking about. Thank you.
Okay, let's press it over to Commissioner Florence, and then we can deliberate as we get forward. Commissioner Florence, go ahead.
Mr. Chair, I'm sorry, if I may, before Building Commissioner Florence speaks, I just want to agree with my brother, David Lawler, that is one of the case that he cited, or the three cases he cited, are cases that talk about the test that you need to use to determine whether a current use of a property is protected as a non-conforming use. It was a case, really, Bridgewater versus Chuckran, a case from 1966, which is a couple of years before the case I'm sorry, it's about 14 years before the case he cited, but there are several others. And bottom line is what they say is you have to look at, does the use reflect the nature and purpose of the use prevailing when the zoning ordinance took effect? Secondly, is there a difference in the quality of character as well as the degree of use? And third, is the current use different in kind in its effect on the neighborhood? And there's a 1988 case that says an existing use will lose the protection afforded to a non-conforming use for failure to satisfy even one of these tests. So that's the test that you need to comply with.
I
and
actually,
at this point, I would.
Slightly different than with the cases that I said. And I think in those cases, the usage was changed. In this case, the use is identical. And it's, the only thing that's changed is the business use has increased. That's it. And that's, I just respectfully disagree. And
Right. The Chapter 48, Section 6 does talk about an extension or alteration of a pre-existing non-conforming use. And it is the board's decision to determine whether the building commissioner was correct in finding that it did not appropriately extend. So at this point, I would like to have Commissioner Florence testify about what the property was like previously, and based on his observations, what's happening there now.
Over to you, Commissioner Florence.
Thank you, Mr. Chairman. Again, for the record, my name is Brian Florence. I'm building commissioner for the town of Barnstable. I do have some screen shares, but I think for the moment I'll hold off, and if I can show them at the end, I'd like to do that. So in 2018, we started to get some complaints about the property. Actually, I'll say we first were introduced to it by Mr. Damon, who came into our office and asked if he could sell cars there. We explained to him then that it would require zoning board of appeals hearing for the expansion of pre-existing non-conforming. The irony here is that the use is allowed to be expanded by special permit. And in fact, in 2021, December, there was an agreement by Attorney Lawler and I that I would withhold enforcement for the time being while he approached the Zoning Board of Appeals to ask for a special permit to increase the scope of the work over there. I withheld it. I didn't pursue it. And then when that didn't happen, when he didn't take the action that he promised he would take, or that his clients promised they would take, we filed a court case. And then things started to move a little bit until they stopped again. So they have the right to ask for a special permit. You have to ask the question, why didn't they? And I think that the record is going to show quite well that the reason they did it is because of the mess that has been made of the neighborhood over there. So in 2018, we became aware of the property that Mr. Murray was taking over the property. He came in, did a good job, talking to regulatory staff, asking what he was supposed to do, and then ultimately he ended up getting permission to move, not to go in there, but not to do the expansions that he wanted to do. We received some complaint. We went over and looked. The nature of the complaints, we disagreed with that it was an expansion at the time. We looked at the property. There had Mr. Murray had put some asphalt in a couple of garden beds that were insignificant as far as I was concerned, so they didn't create a parking lot. There were no more vehicles there than we had been used to seeing, and there was no more traffic in and out of there than we were used to seeing. So we dismissed we basically didn't enforce, and we refused to enforce. 2019, we started getting more complaints, and I could see that the activity was increasing a little bit more, but we didn't find that it was anything that was significant enough to enforce. In 2021, COVID was kind of a blur. That did increase a little bit more there, but really 2021 was when things started to really get out of control, and the continued complaints came in. The complaints continued to come in. We did an investigation. We confirmed that they had, in fact, expanded the use. We did see vehicles for sale. I personally stood in the intersection and watched traffic build up in both directions on Route 6A and 149, waiting for a part supplies truck to get out of the way. And I waited there for 15 minutes, parked across the road, and watched this activity take place while people were trying to get out of the market there, and they couldn't do that. So again, we sent a notice of violation and explained to them that they needed to seek the activities that were an increase of the expansion, or excuse me, an increase of the business that was there, stop selling vehicles, and but that they could go to the Zoning Board of Appeals and request relief to do that. Barnstable is one of the few places that I know of that will allow a pre-existing non-conforming use to expand. And they have that right. They have that ability to do that. Again, as I said before, in 2021, they failed to do that. So we started court action, and we went to court, and we were prepared to proceed. But Attorney Lawler had said that he would like an opportunity to seek a special permit.
Hold on, I just want to say, Brian, you just put words in my mouth.
I didn't interrupt you.
I said I would talk to my clients about that.
Mr. Chairman, point of order.
If you're gonna put words in my
mouth. Attorney Lawler, Commissioner Florence did interrupt you. Can you please just let
it?
him?
But I didn't put words in Brian's mouth.
He's telling his side of the story.
Let him rebut. Yeah, exactly.
Yeah. Thank you. As I recall, maybe I won't say it the way I said it. As I recall, the intent was to dismiss the court case. We did have a court case against the petitioner. Dismiss the court case so that they could seek a special permit. Maybe I'm mistaken about that, but that was my understanding. So here we are. They filed a petition to overturn my decision. Ironically, Cape Quality Collision has, in parallel, filed with the licensing board for their business, Cape Quality Cars, over on Willow Street. And it operates under Cape Quality Collision. And the rationale for doing it is to expand the business. The vehicles are coming into Cape Quality Collision, being fluffed and buffed and sent over to Willow Street. that is an expansion of the use at this location. Let's see. So again, the good news for the business is that they're doing great, and we're glad to hear it. And they have an opportunity to go to the Zoning Board of Appeals, to this board, and request to expand their business. Bad news for the town is they're not being good neighbors. They're not being forthright in their dealings with us. They violated the town ordinance, and they're flaunting the zoning ordinance. I would like, if it's okay, Mr. Chairman, I would go through a series of photographs that shows where they went. As Mr. Lawler said earlier, I will show where they went from not that much traffic at the property to a very large expansion. And I would also recommend that when you're reading the Westlaw paragraph that Attorney Lawler pointed out, that you read the whole thing in its entirety, because it does talk about the fact that the increase must be attributable to growth, and the growth of that business is attributable to Mr. Murray's work there to supply his facility on Yarmouth Road with more vehicles. With your permission, sir, I'd like to go ahead and try to throw some screen share.
Yep. David at Channel 18, does Commissioner Florence have access to share screen, or can you give it to him if he doesn't, please?
Yeah, one second. All right, he's all set.
Okay, I should be, yes. Okay, so I couldn't get to I have 2014 as well, but this starts in 2016. You can see there are 10 vehicles there, 10 vehicles. This is the, I'm having a hard time here. 1 second, bear with me. 2018. You can see that. I know I'm doing it. One more second, sir. I see the dates down here. 2018, now we're looking at about 10, 12 cars. 2019, I think this is when the ownership changed, so it's cleaned up significantly. Just to see, after Mr. Murray's ownership of it, you get 12 cars. But more importantly, the area back here, if you look at just the debris, the junkyard that's starting to be created here, vehicles is one thing, the junkyard is a whole different story. Again, now you start to get more vehicles, not too bad. There's 20 in that shot. And then you get up to, 25, and then when you get the foliage off the trees, you can start to see how they've got vehicles. These are lined up, rolling out, and being used. This is not specifically for an auto body shop. This type of volume, they wouldn't be able to do this in a year. Maybe they can, I don't know, but that's a lot of work to be trying to pump through there in a short amount of time. And then I guess one of the other things I would like for you folks to see is just this. This is what the neighbors are looking at. I was there in 2017, 2018, 2019. This did not exist. This is a junkyard. This is not an auto body shop any longer. So the use is expanded. I respectfully request that you consider our recommendation that this is expansion number 1, and number 2, that you uphold my decision. If they need the relief to expand, they can ask you for it. They don't have to do it without permission. Thank you.
Thank you, Commissioner Florence. Attorney Lawler, did you have any response? Or Attorney Conley, do you have anything to add sort of from the town side, or?
I do not at this point. Thank you.
Okay. Attorney Lawler, did you want to respond?
Yeah, I would like to rebut. First of all, I just want to clear the record. I know Mr. Florence is a very busy man and deals with hundreds and hundreds. I know we're talking to him. He has 500 emails a week. So the agreement with town council and myself was that there was a criminal complaint filed. and we were getting ready to have a hearing before, actually, we were in front of the magistrate. And it was agreed it would be withdrawn. And in fact, the town, rather than me filing a request for a special permit, which I did not want to do because I don't believe we need to, it was agreed that the violation would reissue in a civil manner and that I would appeal it to the ZBA. That was the agreement between the attorneys. So I'm just when I say so, I've known Commissioner Florence for when he was down in Dennis. I know he's a man of his word, but what I'm saying is the record, I'd like to make it clear. The record is that Attorney McLaughlin, and I believe Kate was involved in this. I know that she was maybe now, and Charlie was covering. But before the magistrate, we had an agreement that the criminal matter, the criminal complaint would be withdrawn, and that it was better suited before the ZBA as an appeal of an enforcement order, and not as a, and I actually accepted service of it. So, I mean, that's the record. It's not really relevant with respect to exactly what's happening here, but it's relevant because, I want to make it clear that I do what I say I'm going to do, and that's what happened in this situation. And and previous to that, I discussed with Brian about potentially filing it, but we felt it was better something to handle as an alleged violation, which gives us different rights in this matter. Now, a couple of issues with respect to the actual expansion of the use. Neil, did you ever fix vehicles that were intended for resale with a used auto body shop?
Yes.
All the time, isn't that correct?
Yep.
And that was a substantial part of your business, isn't that correct?
A good part, yeah.
Okay. And the fact that Mr. Florence, we dispute that we were selling vehicles out of that place. He said he saw it there, but that's on one occasion. And if he was told, the photographs I've shown today is the fact that my client has cleaned up the property. It's the ones that I sent that somehow can't be pulled up. It shows cars on the property, it's cleaned up. But if you look at the photographs I attached, the one from 2014, there's a camper. If you would pull that up again, Anna, the one from 2014. And I'll continue to talk while that's going on. You'll see there's a camper, there's all kinds of vehicles in the woods. It just happens to be that my client came in and kind of defoliated the area a little bit, and the photograph from the woods, this property is, the rear of it is woods. To the right of it is a large stockade fence. My clients are more than happy to put up a stockade fence on the left-hand side. We'll have to go through, actually, they were hoping to do that, and then there were complaints that nobody went through Old Kings Highway, and they just put the fence up. That's the only thing that would require that. But if you look at the photographs that are submitted, as far as the storage of used parts, used vehicles, it's virtually no difference than what Commissioner Florence has submitted. Now, as to if there was a car carrier there on one occasion, as Mr. Florence indicated, that's not enough to say that there's a change in use of the business if all of a sudden one parts carrier is there for 15 minutes. There were parts carriers there when Neil was there. The issue is, what was the change in use? Now, my clients I've had, spoken with and, intend to try to keep this as clean as possible, trying to be good neighbors. You heard the conversation about the noise, but there is no dramatic change in use or change to the neighborhood. It's simply, it's gone from Mr. Atwood to Mr. Murray, and there's no change. And that's the reason why we did not seek a special permit. Why would we seek a special permit if we don't need one under the law? What's needed is the fact that this business is relatively the exact same as when Mr. Atwood had it. And to suggest that it's not is folly. It is the same business. And, one or two violations does not change the course of a business. The fact that my client, the fact is that my client owns a duly licensed auto sales business. And the fact that he's a client of himself and sells them in Hyannis, that has nothing to do, the operation of a corporation has nothing to do with the use of the land. If the vehicles are clean and repaired in West Barnstable and then duly transported or driven over to Hyannis, that is no change whatsoever. Mr. Florence respectfully is making assumptions of what Mr. Atwood's business was. Mr. Atwood, who was in the business for 50 years, is saying this is the same business. That's the only evidence that you have of what Mr. Atwood's business was. Mr. Florence was the building inspector, and thank God he was brought on, I believe, in July of 2017. He said the problems were occurring in 18, exactly when Mr. Murray took over. The only difference is two things, and this is not directed at town at all. I want to make very clear of this. And that's what my client's position is. The music changed from Bruce Springsteen to Jamaican music, and the complaint started. That's the only change that's happened in this business. And that's not, again, I'm making very clear, that's not directed in any manner towards any town official. It's directed towards some of the neighbors who are making the complaints. That's the only change. And this business has been in operation since the 40s and has continued solely as an automobile body repair shop. And that's the issue. And you have the people who are there. You have the direct neighbor who owns a commercial building next door. You have the owner who ran the business for 50 years. He doesn't own it anymore. He has no vested interest in this, none. His lease was up and he left. You have the new owner, everybody saying that this is the exact same business. Respectfully to Mr. Florence, I know he was over there. I know he's an honest man. He's going to testify as to what he saw, but what he saw was something for 15 minutes in the course of a business that's been in operation for 80 years. It's not enough. That's all. Thank you.
Thank you, Attorney Lawler. All right, Commissioner Florence, did you have anything else to add, or Attorney Conley?
I don't at this time. Although I will say that I've been there a lot more than 15 minutes, but I understand what he's trying to say, that in the scheme of things, I've been there a lot less than, I've only been here 5 years. The property's been active for a long time. So, I'll defer to Attorney Conley if she would like to say anything.
Mr. Chairman, through you, I have nothing further with respect to the use of the property than Mr. Florence has already said. As far as the agreement amongst council, I do want to just say, as far as what Attorney Lawler said, I was not at the hearing, but I do understand from Charlie McLaughlin that there was an agreement, and I do understand that it was a criminal matter in housing court, and the court doesn't want to hear civil matters like this, which makes sense to me, but that's how we've always handled them. So the agreement was that we would dismiss the case, and I can't speak to the issue about an application for a special permit, but I do know the agreement was, so I'm informed, that the applicant would appeal a new order of the building commissioner. So we issued a new order, and that's what the appeal is. And again, I agree with Attorney Lawler. It's not really relevant to what we're here for this evening, but just to set the record straight on that point. And as far as what I was stating about the cases before, I wasn't making although I do support the building commissioner here, I do think that this was an extension or alteration of a pre-existing non-conforming use. I was simply citing the case law, of which there are probably about 10 cases, including the 3 that my brother referenced. And they just talk about the 3-part test. I mean, it is what it is. That's what the cases say. So the board needs to use its discretion in determining whether this property is a valid alteration or extension of a pre-existing non-conforming use, or if it goes beyond that. Thank you.
Thank you for that clarification. All right, so that brings it back to the board. Does the board have any, board members have any questions for the appellant or Commissioner Florence before we sort of address public comment matters?
Yeah, Mr. Chairman, this is Paul. Question for Attorney Lawler. The bulk of his discussion that we just heard was on change of use, but I don't know that change of use has any play here. I mean, it's not, from what I can read, there's nothing submitted by the building commissioner that says it's a change of use. So I want to make clear, is that an issue or isn't it?
Well, I think it's what he's claiming is, it's an expansion of the use. It's expansion.
I'll speak for myself if that's all right.
Okay, he was asking me the question. That's why I answered.
Oh, I apologize.
Yep.
Paul, are you asking Mr. Lawler or me?
Well, it doesn't matter. I mean, Mr. Lawler, Attorney Lawler brought up most of his past argument was change of use. And I don't know that plays in. You haven't said that there's a change of use, nor do I see any change of use at all. Am I correct?
Understood, David. Please, by all means, feel free to continue.
No. If you want to jump in, Brian, please go. Thank you.
Look, is there a change of use or isn't there? Is this part of this thing? Yes or no?
Well, I'm sorry, go Brian.
Zoom stuff is great.
The violation, give us clarification if the violation is over expansion or alteration or change of use or both.
It was expansion. Yeah. It was over an expansion of a pre-existing non-conforming use. There's no question, and I stipulated at the beginning it was a pre-existing use. I just thought they had gone beyond what was pre-existing.
Okay, thank you. So change of use.
To answer your question, what I was saying is that it's kind of a play on words. Is that and that's why I asked the building commissioner if he agreed that the pre-existing use as an auto body repair shop was, and he acknowledged it was an existing, pre-existing non-conforming use. My argument is that, and the statute really looks to like a change of use, and I was utilizing the word change of use really as an expansion of a use, but it wouldn't. An expansion of a use does not constitute, in my position, a change of use.
Right. Okay. So the issue before the board has nothing to do with change of use. The issue before the board is the expansion of scope, size, and volume of the business. Right?
Yeah, but you're allowed, and it's to the degree that it would change the neighborhood. And as you can see from the photographs and from the testimony, and really the only testimony, Mr. Atwood, is that who was there and ran the business beforehand, is that it hasn't changed. And
well, wait a minute. Let's not fool around here. My understanding is change of use is not an issue.
Correct.
That's a yes or no answer.
Correct.
Correct.
The use.
Okay, fine, thank you.
And I'm suggesting it has not expanded, or certainly not in a manner. And I also suggest that
that's a different issue. That's not my question. That's a different issue.
Okay. Thank you.
Are there any other board members that have questions for the appellant or the building commissioner?
Sure. Herb Bodenstein, I'll have some questions.
Go ahead, Herb.
In the supporting material, it's stated that in one of the cases, it's stated that an increase in use is not an expansion necessarily. But this goes beyond that. It really does.
Let's just stick to specific questions. If you have questions, we'll deliberate in a little bit, but if you have specific questions regarding the presentation or clarification, because we still have a bunch of public comment to get through.
Okay, I have a question for the building commissioner. There was a reference to car carriers and blocking traffic on Route 6A and that sort of thing. Did you see any of that?
Yes, sir.
Very good. I'm sure I'll think of another question after we hang up here, but very good. Thank you very much.
Aaron, go ahead.
Yeah, I just need clarification real quick regarding the property directly adjacent to what I think is the auto body shop. There's a red roof building in Mr. Lawler's slides that looks like it falls within the property lines, but is it officially a part of the automotive business?
My client's home. It's my client's home.
It's your client's home, and she's the property owner?
Yes.
I'm sorry. Gotcha. And he lives right there in that house, and is he in the room tonight? I'm sorry.
Yes, he is, a gentleman in the white beard.
Gotcha. Mr. Sunderland, gotcha. All right, I just need a clarification on that. I wasn't quite sure that what exactly was going on in that particular location. Thank you.
Mark, go ahead.
Thank you. Clarification on 2 points, and if Attorney Lawler or his client would like to answer this, if my understanding is incorrect, please let me know. So my understanding is that the regular hours of the business are 8 a.m. till approximately 5 p.m. Monday through Friday, and that by the accounts of some of the letters wanting us to uphold this is that the business has started as early as 6 a.m. and potentially again that may have gone as late as midnight. How often would you say the business is undertaken outside of the hours of 8 to 5?
Well, my client, Mr. Atwood, testified that he would, again, because this is comparing apples to orange, prior to 2019, and subsequent to 2019, that he would work there nights when he had to, and weekends when he had to, and even Sundays when he had to. How often, Mr. Atwood, would you, if you were busy, be working past 8 to 5?
Quite often.
Quite often?
Quite often, yeah. Depending on the workload, you had to do what you had to do.
Now, I'm gonna ask Mr. Murray, how often, and now you heard that someone said you work there over at 6 a.m.? No, when is the earliest you get there?
I mean, sometime we'll get there early, like I would say maybe like closest maybe 6:30. 6:30 is pushing it, but 7. Like if really something got to catch up on, I'll go in there early. But
just by yourself?
Yeah, no one else comes in before 8.
And at that time, are you making any noise?
No, never. It's normally like would be like either paperwork or something small or whatever till the work hours started.
Okay, so he's testifying that, I don't know if you could, did you hear him?
I did, yes, I can hear it. And as far as the late hours, is that something that goes on regularly?
What about late hours if you were busy?
Okay, so late hours sometime will, late hours definitely. Yeah, we do some late hours, but it's not every day. It's mostly like weekends. And sometimes I do my own personal project because I work so much during the week. I'll have a personal party and I'll stay late for work. But besides a couple of guys having some beers every now and then, that's about it.
Okay. And I just said thank you. I have one other question. I noticed in some of the images that it appears that there's been worked on outside of the main bays. Whether that be oil changes or body work, that type of thing. Again, I'm just going by the images. Is that something that's changed, or was there ever work done on the outside? It seems to me, again, by the description of some of the accounts, that work was almost always done inside the property. Can you speak to that as well, please?
I'm going to let Mr. Atwood talk about that, but I will want to clarify, they don't do any oil changes. There's no engine work, strictly auto body repair there.
Okay, so we're seeing images that have been presented that show different.
Oh, no, sorry, I'm wrong.
Okay, and I do we do have personal projects as well. So like personal stuff, it's different. I'll do motor work on my own personal car, or like a buddy of mine, or something like that. But we don't do that for like the public.
And let me ask Mr. Atwood, was that the same with you?
Right.
Okay, let me ask Mr. Atwood. The question was, did you ever do any work outside of the bays?
Yes.
Can you tell the board about that?
Well, when the weather is good, it's nice to work outside. And the shop could be full. It's only 1, 2, 3, 4 days. And if you had an extra car, need to be worked on it outside.
Okay, thank you. Appreciate it.
There's only could do so much work out of 4 bays of a shop. So.
And Neil, and that was for 50 years, right?
Yeah.
Mr. Chairman, I have one question I'd like to follow up on Mark's theme here. Is there any legal or legally specified hours of business that this business we're talking about is constrained by? I mean, is there a town ordinance or is it an agreement along the way of what the working hours would be?
I'll pass that through to Commissioner Florence on our noise ordinance.
There are no hours for, we don't have a noise ordinance that affects this property.
Right, but I'm just talking about business hours. I mean, can they work 24 hours? Is that legal?
Yeah, we don't have anything that would stop somebody from doing that, except for there's an ordinance under the police rules and regulations that require restaurants and places like that to close down at a certain hour. The only other law that we have that would affect their ability to work in the night is our peace and good order ordinance.
Okay, thank you.
Keeping the peace.
And Paul, to that, that's why I brought the police up and that they've been called and they've never issued a violation. And that's why I brought that up, is because they are in compliance. And since this has happened, they're really trying to clean things up and be good neighbors. I mean, just to avoid having to go through, having the police come by and then walk away without a violation.
All right, is there anyone else from the board that has anything to say? We're still going to come back and deliberate this, but we can open to public comment here. I think we have some people here to speak to this. Everyone satisfied with that? All right, so we'll open for public comment. David from Channel 18. I don't know if you know who's here to speak to this, or you have an order you want to proceed with.
I do not currently. I did see some people with their hands up, but I don't know. I didn't get anything that said there were people here for it.
All right, I see Attorney Kenny, so we'll start there.
Thank you, Mr. Chairman, members of the zoning board. For the record, Attorney John Kenny. I represent 4 of the neighbors of this property, Nancy Trafton, Matt and Samantha Gray, Roberta Goff, and Patrick Watson. I'm just stunned listening to the presentation to suggest that the business today is the same as it was when Mr. Atwood was running it. Is just beyond my imagination. Attorney Conley is correct. The proper case to apply here is Bridgewater versus Chakran in the 3-prong test. And it's whether the current use reflects the nature and purpose of the prior use. That's the first one. You look at Mr. Atwood's affidavit that he created to show the pre-existing non-conforming use. He talks about his use of the property, and it was used as a body shop with related automotive repairs. He had himself and sometimes, not always, but sometimes 2 employees. So maybe 3 employees max, but not on a regular basis. I'm sorry, what was that? I just had feedback from somebody. Cape Quality Collision is converted the use from an auto body shop doing related automotive mechanical repairs. And those repairs that Mr. Atwood was doing, my understanding is was mostly to the vehicles he was doing the body shop work on. The Cape Quality has advertised for body work, engine degreasing, which my clients have seen, automotive work that includes brake jobs, oil changes, tune-ups, and automotive repair. That's well beyond what Mr. Atwood did, but I'm not done. They also do car detailing, and you can still find a testimony on their website about the wonderful car detailing job they did. Where do they do those? Out in the backyard with no proper containment for the water that's being washed off the car. And they also have been selling cars, and Samantha Gray is one of the neighbors here. She can testify to that. I happened to be at the licensing board meeting when Cape Quality got their license to sell used autos on Yarmouth Road. And Officer Gallant at the time specifically told them, you cannot sell the automobiles on Route 6A in West Barnstable, on Main Street, West Barnstable. They said they understood. Was within 1 to 2 weeks, there was a car out front with a for sale sign on Main Street in West Barnstable. So besides what Mr. Atwood did, the related automotive repairs in the body shop, they've expanded it to a full service repair shop. They're doing car detailing and they're selling cars. We checked with car detailers. We couldn't find any that did auto body work. We checked with auto body companies. We couldn't find any that did car detailing. This is a separate and distinct business. Their growth is not as a result of additional auto body work. It's an expansion of the uses, and it's a different in nature and purpose from the prior use. The second test is whether there's a difference in the quality and character as well as the degree of use. Since they took over, the business has expanded into and converted the entire backyard and residence into business into a junkyard. And if we can, Anna, can you bring up the photos that were submitted by Samantha Gray?
I apologize. I can't share my screen.
Should be able to now.
Thank you very much. Is it Attorney King?
For them. Somebody had a question whether or not any trucks were parked along 6A obstructing views, and here you can see it. Now, prior to Cape Quality Collision taking over, there was a dirt strip between the two properties. They paved it. It's now a wide open curb cut from the entire length of the package store property all the way up to past the red house there. And you can see the vehicles parked there. It's impossible to see them coming out. And this is at the intersection of Route 6A and Route 149. We can go to the next photo. This shows work being done in the parking lot, not on the property, but in the lot next door. They routinely extend beyond their property lines into the abutting property. We can go to the next one. That stake you see there, that's a property line. This is junk in the backyard of the house lot, basically. Junk in the backyard just piled up. That's not auto body repair. This is a junkyard. That's another use that they've had that wasn't there when Mr. Atwood was there. We can go to the next one. Hey, you see the aerial photos, kind of before and after. You can see the expansion, and you can see the vehicles behind the house. If we can go to the next one. More junk in the backyard, just a complete junkyard. Next one. There's another look. There's an engine block on the ground there. My clients have a well a short distance from this property, the Grays, and they have young children. And this property is starting to give off the smell of petroleum fuels. We can go to the next one. That's their exhaust system. It's coming out a window. They are not in compliance with Mass Department of Environmental Protection regulations. They do not have proper ventilation. There are times when they've been doing work outside in the yard, spray painting cars, where the fumes have gone into my client's home with their young children, where they basically have difficulty breathing. If we can go to the next one. There's more work outdoors. There's fuels leaking down. There's no containment. When they made changes to the site, they didn't go to site plan review. They didn't install proper drainage. They don't have curbs. They drain out into the street, and it runs down into other people's yards, into a street drain, and into a body of water further down the street. We go to the next one. There's another car being worked on outside, and you can see the drippings on the ground. There's no containment. There's no on-site containment. This runs to God only knows where. And I think, is that the last one, Anna?
Yes.
Okay. If we can go back to Mr. Lawler's, Attorney Lawler's photos. Go to like 304, I think it is. Up, right, no, halfway down the middle there. Nope, down, right there.
I don't think we can see those.
We can't open that up, Attorney
Get
Kennedy.
down at the bottom left corner of the screen, all the way down to the bottom left corner, all the way down.
That's as far as I can go.
No, in your taskbar, in your bar there, I couldn't get that to open, but that's the file.
Okay,
Yeah.
We'll go to some that you can open then. Okay, if you can go up a little higher, Anna. Bring the bot. Yeah, see the backyard? And you've seen pictures of the backyard from my client's property with all the junk. They're suggesting there's been no change. That looks like lawn to me, not a junkyard. In all the photos that Attorney Lawler submitted, you'll see the backyard is used as a backyard for the residents. Since Cape Quality's gone in there, they've turned it into a junkyard and have expanded onto other people's properties. I'll skip on, and I'm going to ask Samantha Gray to testify in just a couple of minutes. The second part of the test, I think we've gotten to that, is basically it's a junkyard. It's unsightly. The hours of operation, Mr. Atwood's affidavit was, he operated Monday through Friday from 8 a.m. to 5 p.m. and Saturdays from 8 a.m. to noon. Under Cape Quality Collision, they stop sometimes before 7 a.m., generally on Mondays through Saturdays. Work begins at 8 a.m. and continues to 8 p.m. One of the tests here is the impact on the neighborhood. One of the board members asked whether there were any hour regulations. Well, this is a non-conforming use. They're regulated by the fact that there's a difference in quality and character and a difference in the kind and its effect on the neighborhood. This is a predominantly residential area. They're working till 8 o'clock, 9 o'clock, sometimes 10 o'clock at night. They're not working, they're partying later at night, and it's interrupting the neighborhood. They are a non-conforming use. They are restricted to the existing hours of the prior non-conforming unless they want to come in and get a change. The third part of the test is whether the current use is different in kind and its effect on the neighborhood. The auto body business operated by Mr. Atwood and his family focused on auto body work and related mechanical repairs. The majority of the time, the work was done by Mr. Atwood alone. At times, the business had up to 3 people, including Mr. Atwood. It was a non-intrusive business welcomed by the neighbors, my clients included. Under Cape Quality Collision, they've expanded services, have led to significant increase in traffic. They block sight lines. They have between 8 and 10 employees working over there at different times. Work once performed in the garage is now performed outside, often in the backyard. They spray paint vehicles out in the backyard. There's increased noise level. There are increased noxious odors. There's concerns about groundwater quality and possible pollution by clients' wells. And expanded hours beyond the normal business hours of the previous ownership interferes with my clients' quiet enjoyment of their property. So the other thing is the other leading case that Attorney Conley referenced is a Barnstable case. It's Powers versus the building inspector of Barnstable. It's also an SJC case. And that case concludes that if a pre-existing non-conforming use fails any of the 3 prongs of the Chukrin test, then it requires a special permit. It constitutes a change of use and requires a special permit. So I'm going to ask Samantha Gray to come on. Samantha, if you can come on board. Samantha, have you seen vehicles for sale out front?
I have.
Have you noticed significant changes in the operations of the property?
Samantha, can you just state your address for the record?
Oh, sure. My name is Samantha Gray, and I live at 960 Main Street in West Barnstable, and I'm a direct abutter of this property.
So you've seen vehicles for sale out front?
Yes.
Have you seen them detailing vehicles on the site?
Yes.
Washing vehicles out in the yard?
Yes.
Washing engine blocks out in the yard?
Yes.
Has there been an accumulation of junk in the backyard of the house?
Yes, a lot.
That's spilled onto your property and abutting properties?
Not as much ours, but not ours, but Mr. Watson's.
In the back, the direct
Yes.
abutter to the rear?
Yes.
Anything else you'd like to add about maybe fumes coming into your home or?
Yeah, would you mind if I just say a little bit about, when I moved in and what I've seen?
Please do.
Okay. So I moved into my property in the spring of 2015. I started looking at our property in earnest in 2013. I knew there was a small old auto body shop next door. The yard next door it looked like a rustic old backyard. There was chickens, things were overgrown, full of personal junk. There were shrubs though, and there was no like view that I had across the yard towards the liquor store. So there were big like shrubs, like lilacs. It was not clear cut. When we moved in, when Mr. Atwood operated, I would on occasion smell fumes and would on occasion hear vehicles being dropped off late at night. But we did not see anyone from the auto body working in the backyard. We did not see what we see now, the daily movement of multiple vehicles in and out of the yard. And I think if you were able to really take a look at all of the photos that were submitted with Mr. Sunderland, you'll see that there's grass, that there are no signs of like the tire tracks and the digging up. The two photos you weren't able to open, I could open earlier. It's all dirt and it's rutted and filled with little plastic, sure signs that this lot has been full and movement of vehicles in and out. But so when I saw the first couple of years I lived there really started to change in 2019. And at first, honestly, I thought for the better. A young couple was taking over. They gave it a nice fresh paint. It looked great on the outside. And I really thought with a young couple, energetic couple coming in, they would actually bring things up to code because I didn't think things were to code before. But instead, I saw just violation of one code and regulation after another. Let's see, I saw an expansion of hours and type of work being done. They started that summer in 2019 with a lot of detailing in the backyard, power washing in the backyard, and that did happen 7 days a week. I remember specifically one time on a Sunday, my daughter's birthday party, and then power washing. I hear movement of vehicles and employees yelling after hours. So that 8 a.m. to 5 p.m., that and occasionally afterwards that Mr. Murray mentioned, I would say it's routinely beyond those hours and beyond that Monday through Friday. And let's see, I started noticing more vehicles in the backyard, many of them derelict showing up. I started noticing larger piles of auto parts and stripped out cars. I started noticing clearing of the abutters lot behind them, an extension of that auto body junk onto the abutters yard lot behind them. I routinely witnessed work happening outdoors. I can see streams of water moving away from vehicles that they're washing, whether they're scrubbing tires, even if they're not using soap now. Any water coming from outdoor work is hazardous waste and should be contained and managed accordingly. We've dealt with noxious fumes, depending on the way that the air is blowing, because they are still operating without a proper air handling system. We smell noxious fumes into the yard. So summer day, sometimes that streams right into the house. I'm smelling it, my kids are smelling it. It's not great. Let's see. So basically throughout all of this, with this expansion, I've really been concerned, we're all on well water. I'm concerned about the impact that this accumulation of this expansion and day in and day out that's having on our drinking water, is seeping into the ground. I'm concerned about impacts to the Great Marsh ecosystem, which is a huge draw of why we're all here. I'm concerned about the health of my family. I'm concerned about the historic character of our community, another reason why I live here. And I'm also concerned about the safety at our intersection with more and more large vehicles being up front and obstructing view. And so I fully support the building commissioner's notice, and yeah, I think that's it.
Have you noticed any additional vehicle traffic in and out to the business?
Yeah.
A significant increase or?
Yeah. And well, I mean, especially since we moved in, because that business was very small at that time.
And then finally, if you, we apparently can't pull them up, but if you look at this photo submitted by Attorney Lawler, you'll see a black roof in one of them. That's a recent structure that was put up that they're now working under. I don't believe any building permit was pulled. I know Old Kings Highway it didn't go through Old Kings Highway, and I know it didn't go through site plan review. So to say that everything's the same is just, as I said earlier, beyond my comprehension. This there's been a change in use, in my opinion, but it's been an expansion of the businesses, multiple different businesses now operating out of there. We fully support the building commissioner's request or citation. We ask you uphold them and send the owners to site plan review, to Old Kings Highway, and to you for proper permits for their business.
Thank
I'm
you.
happy to answer any questions any board members may have.
Mr. Chairman, I have a question.
Go ahead, Paul.
Yeah, I want to go back to the original question I asked, because it seems to be conflicting information, and I would like the truth. It was just stated that the present business hours are restricted to the existing hours of use of the previous ownership. Is that true? And if so, what are those hours?
Who said that they were restricted to those hours?
I did.
Attorney Kenny.
Oh, Attorney Kenny, okay.
Yep.
Attorney Kenny, do you want to respond to that?
Yes, the hours of operation per Mr. Atwood were Mondays through Fridays from 8 a.m. to 5 p.m., Saturdays from 8 a.m. to noon, and occasionally, those were his hours. I believe he did say occasionally he operated on Sundays as well. This is a pre-existing non-conforming use. My opinion is they are limited to those hours. Now, they may be able to expand beyond those a little bit, but not till 8 o'clock at night in a residential zone,
Okay.
not 24 hours a day.
Thank you, Attorney Kenny. I want to correct the record then, okay? That they are not restricted, their hours of business are not restricted by the previous used by the previous ownership, which was the.
There's no special permit
Chakran test.
that says that.
The Chakran test says whether the current use is different in kind and its effect on the neighborhood. Expanded hours into from beyond 5 o'clock when people are getting home from business, and it's interfering with their quiet enjoyment of their home, fails the Chakran test. That limits their hours.
I understand, Attorney Kenny, but that was not the question I asked. Okay, so the answer to my question is there's no legal definition of the hours that they can work, or which is the answer we got before.
Correct. Yes, Paul, I think that's accurate. We're not going by a special permit or something that had specific requirements. And again, we're just looking at whether this is an expansion. Mr. Florence, did you have a follow-up on that?
Yeah, I was just trying to provide some clarity. When I answered the question previously, it had to do with, do we have any ordinances on the books? Was there any law that prohibits them? So the answer was no. Attorney Kenny's talking about a different standard, but both apply.
All right, let's keep going with public comment here, because again, I think there's some people from the public online that would also like to speak about this.
Yeah, there are two people with their hand raised, Heather and Patrick Watson.
Okay, Mr. Watson, if you could just state your name and address for the record.
Certainly. Thank you, Chair and everyone. My name is Patrick Watson. I own 976 Main Street, which is the 3.5 acre parcel behind the liquor store and the auto body shop. And in fact, that what used to be grass separation between the auto body shop and the package store parking lot was my access and easement, which is no longer there. I bought the land in 2019. I'm sorry, 1999. Apologies. And with a group of friends, and we have been walking the land maybe every 2 years or 3 years since. I can assure you that there was not this much junk there ever up until recently. Number one. Number two, they've encroached about 10 feet back onto my property by the width and length pretty much of their property. And now I've lost a lot of vegetation and trees and plants, which is very, very concerning and upsetting to me, because even though it's an empty piece of land, it certainly doesn't mean we're not paying attention and don't care about it and its effect on the community here. So, I know I don't have, as much as of an impact as many of the other neighbors, but I'm definitely here to voice my support in their efforts. And more importantly, I think that, whatever happens here, I'm not sure what the next steps are going to be, but I do feel like there needs to be a containment so that hazardous chemicals are not destroying our water and our property. I think they need to survey their exact property and put up definitely a fence, at least abutting my property in the back, so that there is a definite line of how much they've come on my property. And I would imagine the same thing on the side of the Grays as well. Like I said, I don't know, what happens from here, but it is an issue. It's a problem. It's really affecting my land, even though I don't have a house on there yet. I had some friends that wanted to purchase the land and preserve it, and they decided not to because of this. They walked away from a deal last summer. And so I have really nothing that I can do with that land until this mess gets cleaned up and it's not affecting all of the neighbors, as much as it has.
Thank you, Mr. Watson.
Thank you.
Are there other members of the public here? Again, there's a lot of people in the room. If you want to unmute yourself and speak up, most of these people do not have cameras on. Anyone?
Heather has her hand raised right now.
Yep.
This is Heather. This is
Your
Heather.
name and address for the record.
Sure, Heather Malkani. I live over on Lombard Avenue, 150. I don't have any horses in this race, but I will tell you, tuning in, that well, actually, I think the first thing I want to say very quickly is there was like a minor little, I don't know, jab at maybe an element of racism in here. And the first thing I guess that I will say is that I am married to a person of color and have a child who is obviously also a minority. And so it's super offensive to kind of hear that saying, people didn't care when it was Bruce Springsteen, but now it's Jamaican music. So I do find that a little bit offensive because I don't think this issue has anything to do with that. At least it certainly doesn't for me. And all of the friends and neighbors I have over here in West Barnstable. Yeah, I'm just going to say the business has changed in the past 5 years. It's definitely way more busy. Super junky looking in a way that it wasn't before. My concern is more around the environmental issues. Someone had mentioned cars for sale. I've seen cars for sale. I think there was like a BMW M5 for sale, I don't know, 6 weeks ago, 5-6 weeks ago. And the junkyard element is for sure there. So those are just my comments as someone who doesn't hear the noise, doesn't abut the property, but does drive by there probably 6-7 times a day. Goes to 7Gs to get a vitamin water probably 3 times a week. And I'm all for a nice successful business, but it's also nice to have things cleaned up. Lastly, several years ago, I remember there was it seemed like there was a really big deal about some sculpture that was going in on 6A. And when I finally got a chance to read about it and then see the sculpture, I was like, oh my God, it's a beautiful bronze sculpture set back 50 feet from the road in Barnstable Village, but everybody was up in arms about it. And so it's interesting that over in West Barnstable, we've got like cars with the doors off 15 feet from the road, and I'm not sure how that works, but again, just a comment. Thank you.
Thank you so much. Are there any other members in the public? Councillor Clark.
Thank you very much, Chair Dewey. I am a counselor for precinct 11, and these are my neighbors. I understand the issues in this area, but I do support Commissioner Brian Florence in executing his duty in this area. And I have been the recipient of complaints over the expansion of the permitted rights for what was Hootenan's property. So I do think this, I do thank you for this opportunity to weigh in on this. And it is, it goes to community character and the effects of the property in regards to the property bounds, the effects of the Conservation Commission and the marsh and integrity of our water, of the water quality of our estuary. So I weigh in on this as supporting Commissioner, the Building Commissioner, Brian Florence. Thank you very much.
Thank you, Councillor Clark. Are there any other members of the public that would like to speak to this? I see a few more people. Mr. Petner, I believe it is. You just want to introduce yourself and state your address. You just have to unmute.
There we are. My name is Bill Pletner. I live on Willow Street in West Barnstable. I used to live on Main Street, not too far down the road from the body shop. I've known the property for 27 years, and I know most of the people involved. And I've observed that Mr. Kenny and Mr. Florence both presented photographs to show that there was an increase in business. But the photographs they both showed were during the period of Neil Atwood's retirement, 2017, 2018, when the property was, he had slowed way down and was trying to sell his business. And to compare that to today's business is just not fair, because Neil had a big going business, and I think Mr. Lawler presented that pretty well. So the evidence against, in favor of Mr. Florence, I think has been manipulated. Some of the photographs showing the junk, it's not junk, it's parts taken off of damaged cars. They have to put them somewhere until they can have enough to dispose of them. It may not be the neatest pile in the world, and it shouldn't be on the neighbor's property, but it's not unusual for the property, for the business. So as far as I can see, like I said, I did business with Neil Atwood. I know the property, and I can't see that there's any expansion of the business. There's no change in the building. There's no change in the parking lot. There's essentially no change in the number of cars. I mean, sometimes there's more, sometimes there's less. But that was true in the 40s and 50s too. There's essentially the same number of people working there. The nature of the people's changed a little. Like you said, the music's changed, but it's nice to see a young family trying to go to work and trying to improve the neighborhood and do business. I see it as a right to work issue. I'm sorry, but there may be some minor problems, but they can be dealt with. It's not a case of an extended use. It's the same use it's been for years and years and years. Thank you.
Thank you, Mr. Pletner. Anyone else from the public like to speak? You can unmute yourself and speak up. We have 2 pages here of people of squares. All right, so we did receive a few letters from different people. We did receive a letter from Nancy Trafton, Samantha Gray, who also spoke here tonight, and we received an affidavit from Mr. Sutherland regarding the property. And additionally, we did receive a petition with, I believe, either 49 or 50 signatures, if my count is correct, of residents of the town wanting support of the building commissioner's enforcement action. Did I get everything, Anna, or is there anything else that came in?
No, I think you have everything.
Okay. All right, one last call here of anyone in the room that would like to speak to this. All right, seeing none, I'll make a motion to close public comment.
Can I just rebut a couple of those things, Jake?
Oh, sure. Attorney Lawler, go ahead.
Now, Sam, you heard some testimony about paving the parking lot. That's your land.
Yes, the parking area that was paved belongs to 990 Route 6A.
Now, you
The
also,
property stake that you saw is also my property.
and you also heard some talk about an easement. That's on your
Right,
land?
when that Patrick Watson was talking about the right of way, the right of way is on 990 Route 6A. And it has, as far as I know, he has never used that
Yeah,
right
but it's
of way.
not, it's not on this land.
It's not, it's on my land.
And then, and for a point, and I know there's a petition out there, but this isn't a popularity contest. This is an issue as to whether or not it's an issue of the facts. And I know a lot of people don't like the fact that there's an auto body repair shop on 6A. That's not the issue because it's pre-existing, non-conforming in that capacity. And with respect to the issues of environmental issues, first of all, the DEP has been by twice and tested the land and it came back clean. There's been a 21E on the property. It came back clean. It's also not in your jurisdiction, respectfully. That's a Board of Health issue or some other boards that would deal with that, though it's certainly emotional. And we understand people talking about that. But I just want to point out a few things that the witness did indicate that there were fumes, there was this, there was that. And this is an auto body. And I want you to look at the photographs. Look at that the photograph from the 80s and look at the photograph from 2014. It's not that different. And one of the things that Mr. Atwood said when we were on mute is the business has changed a little bit in that it's gone from metal parts to plastic parts. So they are being piled up, but that's an evolution of the business. That's not a change of anything. And they have to be stored on site and then recycled as indicated. Also, there was a picture of a car carrier. How do you think the cars got there from Mr. Atwood? They came by car carrier. They came by tow truck. That's how they get there. And when they drive them away or they take them with them. So this particular, I can't hear you, Herb. You're muted, Herb. No, we're starting with someone else. So the issue is simply that, it's not. I mean, Mr. Atwood he was the one here, and the other gentleman who was there for 27 years. And I suggest to you that that's the standard. And I don't, we've gone on for a long time, so I'll stop talking, but I just wanted to clarify a few of those things for the record, that it's not an environmental issue. It's whether or not there's been an expansion that would rise to the level of the court rulings that were provided to you. Thank you.
Thank you, Attorney Lawler. All right, I will make a motion to close public comment. Do I have a second?
Herb Bodenseek will second that.
All right, so roll call vote this is to close public comment. Herb Bodenseek.
Favor.
Paul Bernard. I think you're muted.
In favor.
All right. Mark Hansen.
In favor.
And Aaron Webb.
I'm in favor.
All right. The public comment is closed. Does anyone need to take a break or are we good to deliberate this?
I'm good.
I vote to push through, Chairman.
You what?
I vote to push through at this point.
Okay. All right. All right. We'll push through. All right. Does anyone have any thoughts? Follow-up questions for anyone? Go ahead, Aaron.
So unfortunately, these cases just are the worst of the worst for us. And I understand it's our duty to hear them out and make a final decision. Both parties have presented themselves, I think, pretty clearly at this point. I hate that a young couple is trying to make a living and increasing business. And I do believe that that's sort of all that's happened here. And yet it has caused neighbors and such to find, to struggle with quality of life issues next door. I personally, I can't, it's hard for me to judge on this particular case at this point. I'm curious to hear what other board members have to say. The evidence has been presented pretty clearly, I think, on both sides. I do respect Commissioner Florence's job in terms of, hearing complaints from community members and going and seeking his own interpretation of such complaint. I feel like the business owner currently there could probably do some things, and maybe some have been done. I'm disappointed that Attorney Lawler's most recent photographs did not, weren't able to be shown, because the business owner is trying his best to become, a better neighbor and respect those that live and work around him. Then he deserves some props for that, and maybe that's the remedy that could solve this case. So again, at this point, I really think we're in a, this is going to be a tough one for sure. So I'm definitely curious to hear what other board members have to say before I make my final decision.
Mr. Chairman, this is Paul. I have a question. What is the penalty here? I mean, but if we, what is the action? So if Commissioner Florence's stop and desist is, if we agree to support that, what happens to the business? I mean, is it shut down?
They could go for a special permit. I mean, they can go to site plan review and apply for a special permit. I mean, Commissioner Florence, do you want to respond to that in the process for them?
Thank you, Mr. Chairman, and respectfully, well, the options are basically this: if you uphold us, then they have two options. They can go to the zoning board, or they can appeal to court. And that's the options for Mr. Murray and Mr. Lawler's team. If they don't, if you vote to uphold us and they don't go forward and take care of either those issues, appeal it either to you or the court, then we would proceed with court proceedings as this started out.
So let me understand this. So in the period of time it takes them to say file before the board, that's several weeks, I would assume. Same if they brought it to court. Well, in the meantime, are they open or closed?
They're open. There's a stay on proceedings until they take action. Yeah.
Okay. Thank you, Mr. Commissioner.
Mark, any thoughts or questions?
A couple quick thoughts. I mean, I think both parties have clearly, stated where they believe it to be. I think what probably this is more a case of, rather than expansion of business, I mean, really, if you look at it, is probably not being the greatest stewards in the neighborhood. I do obviously have concerns about things about how the business is being done, as far as if you were if you were running a new business, or if this was going to site plan review, obviously there would be hours set. We've obviously had people come in front of us to expand hours, but that was already set by site plan review. Where this is existing non-conforming, I believe, outside of the hours being substantially greater than where they were before, and I still don't quite have clarity on whether that holds any sort of water as far as what the temporary hours were. These complaints don't come out of nowhere, and I feel like there has obviously been an effect to the neighborhood. Whether or not that again creates a change in use, or I don't know if that's an expansion of use, but it's certainly causing, I'm willing to bet that the number of times that police have been called to the property prior are probably zero. I'm all for expansion of business. I just believe that, in this case, I'm kind of questioning whether there's a true show of where it has been expanded.
Okay.
Per Bonesig, Mr. Chair. Well, I see. Well, I've got a whole bunch of concerns, but not necessarily relative to zoning. First off, we've got trespassing. We've got air quality with the modern body shops do not any longer do spray painting outside, period. They just don't. Okay, Google it. We've got the water quality, which is appalling, that any sort of pollutants are, but My main concern is, I've got so many, there is no main concern. But as far as the expanded use, I would say probably the one clincher for me is the use of a car carrier. They hold like, what, 6 or 8 or 10 cars? If this was a legit body shop, you have a car carrier that holds 1 or 2 cars. You wouldn't have a car carrier that holds multiple cars. So the expanded use is a given right there. So I support the building commissioner's decision on that alone. Now, Attorney Conley had mentioned, and I don't know if I got this right or not, but violation of pre-existing non-conforming use. Basically, you lose your protection under that. Did I hear that correctly, Attorney Conley?
If I may, through you, Mr. Chair, I was reading the test of the case Bridgewater versus Chuck Grand, Powers versus Barnstable. It sets forth a 3-pronged test that says if the applicant fails to prove, the applicant has the burden of proof that they have a pre-existing non-conforming use. If the expansion, alteration, or the change in use or whatever is at issue doesn't meet all 3 of those prongs of the test, then the pre-existing protection is lost.
Attorney Conley, can you just, I was going to do it, but I think you can do it more clearly. Just reiterate those 3 prongs for us as board members. Just read them sort of in clarity.
I'd need a minute to get that back on my screen.
Because I think that's what we just sort of have to, I mean, I personally think that's what we have to focus on here is these 3 prongs and how this use and this potential expansion of use is.
Mr. Chairman, I have them right in front of me if you'll permit.
I do have it. I can.
Okay.
It's chapter 48, section 6 is the statute, says the zoning ordinance or bylaw shall apply to any change or substantial extension of such use. The 3-part test for determining whether a current use of property is protected as a non-conforming use comes in the case I mentioned, Bridgewater versus Chuckran, 351 Mass 20. It's a 1966 case. First, does the use reflect the nature and purpose of the use prevailing when the zoning bylaw or ordinance took effect? Second, is there a difference in the quality of character as well as the degree of use? Third, is the current use different in kind in its effect on the neighborhood? And then I did mention another case, Green versus Board of Appeals of Provincetown, which is a 1988 case that said, that's the one that says an existing use will lose the protection afforded a non-conforming use for failure to satisfy even one of these tests. And then, as Attorney Lawler mentioned, there are several other cases, key cases that give a good outline of the 3-pronged test that I just mentioned. And one of them is the Cape Resort Hotels case he mentioned, which is a 1982 case, I believe. Powers versus Building Inspector of Barnstable. And there's about 7 or 8 other cases that set forth that very same test, the 3-pronged test from the Bridgewater case.
Thank you. Herb, do you have any more follow-up or does that help you have clarity? What's sort of before us?
So I'm just appalled by this whole thing. But basically, the Falmouth case, the increase in volume does not constitute a change in use. I don't think that applies here. So I don't know. To me, it's a clear-cut expansion of use among a number of other violations that really aren't of concern to us, but hopefully will be addressed. Just appalling. That's all I have to say.
So, I mean, I'm having a little bit of a hard time, fully identifying, which we've had in the past with a similar case to this I think doing more cars, repairing more cars is fully acceptable and evolving. The evolution of business is obviously is expected or hoped for. That's something we want to encourage as times change. I do have a hard time when I look at the GIS maps of this place and I drag it from, 1985 to I think 2014, watching in these past years here, these aerial pictures that Commissioner Florence has, there's a clear expansion into the back area of, I would call that car storage or junkyard, whichever we want to call it, versus what was happening before seemed to be cars that were actively being repaired close to the building. It looks like there also is storage of, there were some boats, and in the pictures that were submitted, there's some machinery. There's like a bobcat that looks like that's just sort of stored there, things of that nature going on. So I do, again, when we go back to the three-pronged test that I think is before us, is this current use nature, is the same as the nature and purpose of the prior? I think we're close there. We're all in agreement that this is auto body shop, and there is some evolution to that. But then the quality and character as a degree of use, if you're looking at that, it's clearly expanded into the back areas of the lot, and it doesn't seem like this expansion stays within that previous degree of use. And then the effect on the neighborhood, I think we have a pretty strong case from our abutters and neighbors that this was an acceptable level of business before, and now it has expanded to an unacceptable scale of business. Those are sort of my thoughts.
Totally agreed.
Do any other board members have any other comments or thoughts on a position on it?
No, if I could follow up on that, Mr. Chairman, I think that was my thing, that again, I think you expect normal expanse in business. I think obviously doing things the proper way is expensive. I do believe that the main issue here, and if we look at statements made by the public, that they did understand, that this was a body shop. They did not really have any particular issues with what was going on, and really speaking specifically to hours, noise level, there seemed to be a general concern for the neighbors around, where I think that's been lost. I think where that is the change that really has precipitated most of this. Again, we're not here to determine whether or not they're meeting, DP regulation or any sort of environmental regulation. We're here to determine, was there a change, and I believe there is. Again, which has probably precipitated most of the complaints.
Aaron, did you have something comment? Go ahead.
I do, yeah, real quick, just going back to what Herb said about a car carrier. I don't see in the photographs, evidence per se of a car carrier. I've seen, there is a photograph of a tow truck, and again, clearly needed in the use of an automotive business is a tow truck with a flatbed truck with one car on the back to drop off and pick up vehicles. So again, that seems like a minor point, although it was Herb's major point, was that a car carrier is now.
There's a photo of it. There's a photo of it, and there's a butter's testimony. There's a photo right in the package.
I saw the one photo of a tow truck. It didn't appear to be a car carrier.
No, it's a great big blue car carrier that holds like 8 cars.
Yep.
I think the discretion here is like, can they handle a 18-wheeler full of cars to repair, or a wrecker? Historically, probably a wrecker came in and dropped one car off, and it got repaired within a 2-week time period. Whereas now we have car storage and a supply line here of cars to be repaired. We can't make any assumptions, but it's been presented or thought that maybe this is a supply for sale, for used car sales. They're being dropped off, potentially bought from auction or something like that, dropped off at 6 or 8 at a time to be repaired. And that's why we have a storage lot in the back part of the land now.
So,
do you have any other thoughts?
Mr.
Well,
Chairman,
that would Herb's thinking, that would constitute a used car business. An auto body shop takes in cars from customers that need repair. They repair them and give them back to the customer. Wholesale auction, cars coming in and fixing up 8 cars at a time. That's totally different from a little mom and pop auto body shop.
Yeah.
You know, I'm sorry.
Go ahead, Paul.
You know, I think we really need to think about our responsibility to other regulatory agencies, even though environmental concerns are not in our realm of business. There still has to be some concern for it. We've run into this before. The West Main Street, it's now the dollar store. There was the, I guess, former gas station on 6A across from more or less across from the fire station next to the Dolphin. It's just countless examples where we really have to consider basically the very fragile Cape Cod ecosystem.
Yeah, but Herb, we just have to be focused on what's before us, whether this is
Understood.
or not.
Jake,
Paul, go ahead.
Jake, I've been communicating I've been communicating with the attorney. Normally, if this was in person, I'd be talking to Kate personally.
Yep.
We just had a slight communication about maybe trying to reach some out of situation resolution and hopefully continue this matter. I know I don't know where you want to continue it before a vote. That will allow, normally I'd probably work this all out if we were in person, but it's difficult through non-verbal communication.
Attorney Conley, your thoughts?
If I may, what I also just responded to David's text with was that if he did request a continuance, I would have to check with the building commissioner and get his thoughts on that, given the history of the case.
Okay, if everyone's comfortable speaking about it in public forum here, Commissioner Florence, you want to speak to this, or do you want to talk to Attorney Conley offline? Or
I'm comfortable speaking about it. So as this is an appeal of the building commissioner's decision or the administrative official decision, I think that the case should be concluded. All of the options available to Attorney Lawler, no matter how this case is still available to him. He still has the option to seek a special permit. He still has the option to appeal this matter to court. He still has the option to clean up the yard and reduce the scope of the work that's going on over there, quite frankly. And there would be no case. The town does not want Mr. Murray out of business. We think that that's a valuable, viable part of the community, and we respect him and his business. And so we don't want him out of business. We just want either to go back to what it was or follow the rules like everybody else and seek a special permit to expand.
Brian, I actually think that could result in him being out of business, and that's why I'd like the continuance and work with Kate if that's at all possible.
Attorney Conley, what's your thoughts, or are you leaving the discretion of a continuance to the board?
Well, it is the board's decision ultimately, and my client in this situation is the building commissioner, so I would defer to what he just said. If the board wants to continue it, I'm happy to talk with Attorney Lawler about options. I understand that some of the options do include coming back to the board for a special permit. So
I would talk to Attorney Conley if that's at all possible, because I did listen to some of the board members, and I think we can work something out that would be agreeable to the board.
Okay. Public comments closed, but Attorney Kenny, if you have something sort of short here, I'll listen.
Well, that's my point. Public comment is closed. The board's in deliberation, so there shouldn't be any additional evidence put in. I would suggest you just move forward and make a decision.
Yep.
Again, I'm not asking to put in additional evidence. I'm asking for a continuance that I might be able to work something out with it. That's all. I've been before this board's. I've never seen a board not grant a continuance for, trying to negotiate. I mean, I think obviously, I think negotiations are always encouraged.
Board members, let's sort of get a thought on, do you feel we should move forward to a vote here on Commissioner Florence sort of wishes? Do you feel like we should continue this? Paul, thoughts?
Yeah, Mr. Chairman, I'm still, sensitive to what Herb says, although that's not part of our ruling. I'm sensitive to what the other board members said with respect to when this was a smaller business that didn't bother anybody, and the expansion of it clearly is bothering people. And I think that's where the building commissioner is coming from too. I'm not sure what the remedy is, though. I mean, you can have a continuance, and what are they going to do? Make the business smaller? On the other hand, if they go for a special permit, what's a special permit going to say? Can we make our business bigger? So I don't know. I'm confused as to what the remedy to the applicant is with respect to either way, either a continuance or that makes this go away, or a special permit. I don't know what the solution is to this. If they're the same, then go get a special permit.
Well, I think that Paul would allow us to maybe possibly do that, and then you would set the parameters. Your board would set the boundaries and the guidelines as to what this business may or may not do.
Yeah, I don't think a continuance would change my decision.
Continuance would allow us that opportunity. I think a negative decision could shut this thing down permanently. And I would ask that we just continue this, and it's only, and then and then I could talk to Kate offline, and we could try to work something out with Commissioner Florence and then the town. I'm seeing
what is the exact concern that it would shut it down? I'm not seeing where that's going.
Kate Rod, that you may lose your pre-existing status, which would shut us down.
I think we're all in agreement that the pre-existing is pre-existing as an auto body shop at the scope and scale that it was pre-existing at. And your client went into that property, planning to lease that space, to operate a similar operation. Had he gone in there saying, I want to grow this business into the backyard and having all sorts of other things going on there, he approached the building commissioner about having that conversation, and it was said, no, you would have to go to get a special permit, and that option was granted.
I understand that,
come to us.
But what I'm saying is if that's a mistake, and then in fact it might result in them losing their business completely, that's why I'm just to explore that. I'm looking for the 2-week continuance, and then potentially work something out with Kate. And we could either come back. There would be no further testimony. I would ask that those 2 pictures were put in. I'm just asking that we have, a 2-week continuance, and I might be able to work something out with Kate. And then,
if I may, I'm a little bit uncomfortable the way you're wording it. That like I'll be making the decision.
No,
I don't.
No,
really
I'm sorry. I apologize.
My role.
The building inspector. I'm sorry. I have a tendency because I work with the lawyer, but ultimately.
Yeah, no, I understand that, but the board still, and I agree with both you and Attorney Kenny that continuance does not mean any further evidence coming in. The hearing is closed. So a continuance would just be the applicant allowing the board some additional time, but to do what, I'm not sure. We could certainly talk. I simply cited the case, the Powers and the Chakran case, but it's still the board's determination of whether this is an acceptable extension or alteration of a pre-existing non-conforming use. I don't know that it shuts the business down. If they decide that it's not, you would still be in a position to file an application for a special permit and get approvals for the uses.
I think I still, again, I just want to, some of that language you read, quite frankly, scared me my client a little bit. And I would like to ask for that short continuance so we can explore that. And then
so I have a question of procedure here.
Go ahead, Paul.
If there's continuance, I mean, can Commissioner Florence pull back his stop and desist order? Or is that legally on the table now that we have the hearing?
Commissioner Florence, go ahead. I don't know the process of that. Go ahead.
Thank you. To answer your question, Paul, no court is going to take my case if there's somebody trying to do the right thing. In this case, we have an enforcement order to cease and desist the expansion or seek a special permit. So as long as they are diligently pursuing that, as I said, the town has no interest in shutting this business down. That's not our intent here. We just want them to follow the rules like everybody else. So as long as they're diligently pursuing the appropriate options and compliance path, we have no issue with them.
So does that mean that, and this may be a legal question, does that mean that if they do, in this 2-week period, things to satisfy your cease and desist, you can withdraw it?
Absolutely.
Okay.
Yeah. And the call enforcement is mine. I can pursue it as aggressively or as I can pursue enforcement according to the rules and the regulations. I have no interest, and I'm not compelled to start continue enforcement action against them and drag them into court while they're trying to get zoning board of appeals approval. So I have no problem with you folks making a decision and then them following whatever path it is they want to take, whether it's to reduce the scope, get a special permit, or appeal it to court. They can do whatever they like. All those options are available no matter how you decide tonight.
Hey, Mr. Chairman, Herb Bugson, point of information.
Sorry, say that again?
A point of information, Mr. Chairman. If we vote to uphold the the building commissioner's complaint, may they still file for a special permit?
Yes.
So, I don't know.
Again, I'm just confused if we delay this, what's going to be worked out. Either they come back for a special permit or they make the business smaller if we say that it's building commission, if we uphold the building commissioner's decision.
Well, the decision becomes not the board, the decision becomes the building commissioners.
Right, there's a stay, as the commissioner, Mr. Commissioner said. I move that we put it to a vote.
Okay. So
Again,
we have a motion to deny the request for a continuance.
Aaron wanted to make a point real quick.
What I'm confused about is that there's no parameters to the size of this business. This business exists as a auto repair shop. They can decrease the size of the business to how many cars? 10, 12, 15? What is that? There's no parameters to the business. The business is the business. They are in the business to repair automobiles. So we don't have a guideline to say that, okay, they're going to clean up the pile over here and move 5 cars out of the way. Is that going to satisfy a building commissioner's complaint? And it's not even the building commissioner necessarily, it's neighbors that have brought this attention really to Mr. Florence's desk.
Which is one of the prongs of the test here that's before us. Right. The third prong is its effect on the neighborhood changed from how it was operating for when it was pre-existing non-conforming, when it became pre-existing non-conforming. And so it expanded and started affecting the neighborhood in a different way, in a different light. I think we have a lot of evidence from neighbors and people testifying to that it's affecting the neighborhood differently now. That's expansion.
I heard Bonesy. I have another question.
We also have evidence presented by Mr. Pletner. I'm sorry if I mispronounced your last name, but who's lived in, again. So I'm just, what bothers me about cases like this, in this particular case, is that the parameters are such that there really is no definable measure of how best to solve this problem, right? Again, this business is growing, it's doing its thing. So over the years, when Mr. Atwood had it, he had several cars doing different things coming in and out. Now the same, is happening. So I just, that's what makes me so torn about these things. I wish that the new business owners would, and maybe they have, as Mr. Florence has suggested, taken steps to remedy some of the issues that were presented or that were discovered by Mr. Florence on his visits, which would probably solve most of these issues. And so, again, until we know or have the evidence that that's happened, we're going to be sitting in the same chair, the same seat, over and over again. So I am in agreement that we should move forward and make a decision here. I'm really.
I heard Bonesy. I have another question. If this was an auto body shop on, let's say, Willow Street, would it not have a whole bunch of limitations as to density and things of cars and grease traps and?
Only if it was new.
Again, but that's not what's before us, sir. Let's just stay focused here. But I mean, I think to your point of going to other locations, when a business expands, oftentimes it has to move locations to something that can accommodate their growth and expansion. And it, to me, is starting to sound like that is what has happened here, that this business is growing and getting bigger, and they're trying to fit it into a small box. You made a motion to deny the request for a continuance. Does anyone want to second that?
Yeah, this is Paul. I'll second it.
All right, we're taking a vote on denying the request or making a decision that we're going to vote on this tonight. Herb.
In favor.
Paul.
In favor.
Mark.
In favor.
Aaron.
In favor.
And I'm also in favor. Okay, so we're gonna vote tonight either to uphold the building commissioner's decision or to overrule the building commissioner's decision to order the cease and desist. Does anyone want to make a motion?
Some of.
Yeah, this is Paul. I move that we uphold the building commissioner.
Okay.
I'll second that.
Okay, this is a vote to uphold the building commissioner's decision to order a cease and desist on the property. Who is the second?
Mark.
Mark. All right. Roll call vote. Herb Bodensee.
I'm in favor.
Paul Pinard.
In favor.
Mark Hansen.
Specifically by the three-prong, I'm in favor.
Aaron Webb.
Regretfully, I'm in favor.
And I'm also in favor. So we voted to uphold the building commissioner's decision. I would hope that the applicant comes back to us for a special permit if they would like to continue to expand the business at this property.
Be very
Thank you very much, everybody. Thank you.
Thank you.
It's late. Thank
Yep.
you very much.
Mr. Commissioner,
Thank you, Building Commissioner.
Yes, sir.
excuse me, Mr. Chairman, in closing, I wanted to make clear that someone had raised an issue of racism or something else. So I just wanted to make it clear that during this hearing tonight, that I saw no signs nor heard any words that had anything to do with color or racism or anything. That I think comment had to do with submitted material or other material, the letters or something, but certainly nothing to do with this hearing tonight.
I agree. I agree. And I did not, yes, that made my skin crawl. I think we very fairly deliberated the facts here, listened to the facts, the public, and made a strong decision amongst
Thank you for your time. Thank you, Mr. Kennedy. Thank you, Building Commissioner. Thank you, Kate.
We look forward to seeing you back.
Thank you, Board of Appeals.
All right, so moving on to our final item. Do you guys want to take a break or we want to try to push through? Okay, we'll keep going. All right, appeal number 2022-051, Michael F. Schultz, trustee of Race Mill Realty Trust, has petitioned for a variance pursuant to section 240-14E, bulk regulations, footnote 2. Petitioner proposes a subdivision of land where a parcel has proposed lot area of 72,600 square feet, where 87,120 square feet is required. The subject properties are addressed as 7 Mill Race Road, 1479 Race Lane, 1465 Race Lane, 1451 Race Lane, 1437 Race Lane, 12 Old Mill Road, 6 Elmwood Road, 20 Elmwood Road, 34 Elmwood Road, 27 Camelback Road, 11 Camelback Road, as shown on assessor's map. 062 is parcels 071, 072, 073, 074, 075, 076, 077, 094, 095, 096, and 097. The lots are located in the Residence FRF zoning district. Again, sitting on this is our regular members, Herb Bodensee, Paul Pinard, Mark Hansen, Aaron Webb, and myself.
Mr. Chairman, I'd be happy to, Denise Johnson has been here the whole evening. If she would like to sit on this, I'd happily recuse myself.
Denise, do you want to sit on this tonight? Aaron's offering to step down and go to bed probably.
No, I'm going to stay on. I just want her to be.
Denise, are you there? You're muted.
Totally up to you. No pressure.
I can do it either way. I don't care. Yes, I am here. I did learn a lot from that last case. So.
And Denise, just be known, if one of us isn't here at the next hearing with them, you could have to step in, just so you know, on the other one. So feel free always to ask questions if there are things.
Okay. Okay. Thanks.
All right. So we'll have Denise sit on this as well, and Attorney Schultz, over to you. Take us home.
All right. Good evening, Chair Dooley and members of the board. For the record, Michael Schultz, trustee of Race Mill Realty Trust. As noted in the opening comments, a variance is being sought due to the merged lots lacking 5,932 square feet. We're short that much area in achieving 3 compliant 2-acre lots. I did submit a memorandum to the board dated October 21st, 2022 to assist the board in reviewing the requested relief. As set forth in the memorandum, the properties that are the subject of this petition are shown as lots 5, 6, and 7 on Land Court Plan 37712-B Sheet 2, which are a portion of a 60-lot subdivision which was created in 1980. In 1980, the Roman Catholic Church of Fall River purchased 12 lots, lots 1 through 7, 22 to 25, and lot 61 from the original developer. At the time of the purchase, the Roman Catholic Church had 11 conforming lots, all of half an acre or more. Since the creation in 1980, all of the lots in the 60-acre subdivision have been developed with the exception of the 11 lots. Although conforming in 1980, the successive zoning amendments in 1985 and then most recently in 2000 to minimum bulk area have merged a portion of the lots. The town assessing division does tax each of these 11 lots separately as attached to the memorandum. As shown in the proposed plan by Hayes Engineering, the petitioner is proposing an effective division of the land which would not create any new lot lines, but would significantly assist in the clarification of the merged lot lines. The proposed Lot A would reflect a combination of 4 lots and would contain over 2 acres of land. The proposed Lot B would reflect a combination of 4 lots containing over 2.10 acres of land. And the proposed Lot C would be just shy of 2 acres at 1.667 acres and would be comprised of 4 lots as well. Again, collectively, the 3 proposed lots are a mere 5,932 square feet short of 3 conforming 2-acre lots. The properties are surrounded on all sides by roads, which prevent the ability to acquire any area to make the proposed Lot C less conforming or conforming. In support of the requested relief, the petitioner would suggest that the board could make the findings for variance based on the evidence that has been submitted, that 1, owing to circumstances related to soil, shape, or topography of such land or structures, and especially affecting the land or structures, but not affecting generally the zoning district in which it is located. I would respectfully submit to the board that a shape issue does exist due to the successive mergers, which have created really unclear lot lines in the configuration of the 11 conforming lots. The proposed plan does reflect 2 conforming lots, each over 2 acres, and 1 lot that's just under 2 acres at 1.667 acres. It would help clarify the lot status. Let's see. Secondly, a liberal enforcement of the provisions of the zoning ordinance would involve substantial hardship, financial or otherwise, to the petitioners. I would respectfully submit to the board that the hardship is the inability of the effective development and all of the lost time. It is land court property. What we're doing is we're not making any new lot lines. If we were to go to land court seeking to make these 2-acre lots or shift the lot lines, it would take an awfully long time to go through. And third, that the desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the zoning ordinance. And I would submit to the board that the clarification of the lot lines and assessing records would be in the public interest and would not be a detriment to the neighborhood. Thank you for your time, and I'd be happy to answer any questions at all.
All right. Does anyone have any questions for Attorney Schultz?
Yeah, this is Paul.
Go ahead, Paul.
Attorney Schultz, in this, in one of the maps that was provided, or plot plans, I mean, including the parcels under consideration, shows a huge number of lots, and I understand they're all built out except for this area.
That's correct.
So all the other lots are far less than 2 acres.
That's correct. They're all almost exactly half an acre.
Okay. The other question I have is, you're intending to make these 11 or so lots into 3 parcels. Have the other 2 parcels been consolidated yet, or is that dependent upon the answer to this third one?
That's dependent on the answer to the third one. So,
Okay, so Mr. Chairman, I would propose that eventually when we get to the conditions, that however we rule on that, if we decide to approve this, then the condition is that it's contingent upon the consolidation of the other 2 lots as proposed.
Does anyone else have any questions for Attorney Schultz? Nope, seeing none. I guess one question I had here, I'm shooting from my hip. If we were to create all of those lots today, that'd be creating a subdivision, what would the affordable component required be here? So I believe we have a bylaw that would require a certain number of affordable.
well, we're really not creating any new lots, just for clarification. So what we're doing is, the only thing that we're doing is unmerging lots 5, 6, and 7, because the combination of the other lots, they're all conforming, and any conveyance would include all 4 lots. Does that make sense?
Mm-hmm.
So the only thing that we're doing is unmerging lots 5, 6, and 7.
Okay.
Can I understand? I'm sorry. You're unmerging 5, 6, and 7?
Correct.
Well, they're unmerged now, aren't they?
No, it depends on the compilation, and that's part of the requested relief. It's how you look at the land. Bulk zoning is now 2 acres, and it would be how you lay out the lots. And as you're looking at this parcel of land, it's how you carve it up. And I think what we've done is we've looked at an effective division. So we're not creating any new lots aside from the proposed lot C, which is carving, and it's really making it pursuant to a variance where we could convey lot 5, 6, and 7.
Okay, so
there's no rhyme or reason of how they would have merged, right? I mean, there's no.
Right.
That's correct, and that's the issue, really, right? So we've looked at it, and bulk zoning is 2 acres, so it merges to the extent where you make it complying, but the complying lot lines aren't evenly divided. And so we're doing our best in this division. The compilation of lots 1, 2, 24, and 25 are a little bit over 2 acres. The compilation of lots 4, 22, and 23 are a little bit over 2 acres. And we're just trying to carve off the lots 5, 6, and 7, which are just under the 2 acres.
So by right, they can create 2 lots. If we give a variance, they can create 3 lots.
Correct. And it is important to note, and I've stressed, we're only 5,932 square feet short of 3 complying lots.
Are these lots for development, or are they for sale, Attorney Schultz?
They would be for either or, I think.
Any other board members have questions? Denise, Herb, Aaron?
I think it's pretty clear cut.
Okay. All right, let's open public comment. We've got a few people here from the public, it looks like. Does anyone want to speak to this?
I don't see any, at least for now.
Okay. Christopher, just unmute yourself, your address, and name and address for the record.
My name is Christopher Cooley. I live at 9 Old Mill Road in Marston's Mills. I am the very first house on the corner of Race Lane and Old Mill. And I look directly into the lot across the street. My main concern with the development there is for 12 Old Mill Road. I'd like to know if it is up for construction, where the driveway would be. I'm also concerned with the driveways on Race Lane that are so close to that stop sign due to the fact of it's a very dangerous intersection. And once you come over that hill, it can get scary. So I'm just concerned with the construction and congestion that'll happen. And also, of course, where the line would be for the driveways for 12 Old Mill Road. So yeah, those are my concerns.
Attorney Schultz, do you have any comments of why you're choosing the lots to put together and other lots based on some of like frontage, road access, things of that nature?
It was merely just a nice, effective compilation of the lots and to not be altering any lot lines. So that we would have, we'd have the two conforming lots just over 2 acres apiece, and then we'd have one lot that's just under the 2 acres.
And so would this have to go to planning board for review or be an A&R?
It would not.
Okay. Was that intention? If you were to have no lot lines here and the whole thing's merged into one, and you'd have to go to the planning board, correct?
No, this is already laid out. So all we're doing is it's from a merger perspective, we're combining the certain lots. Does that make sense? And it's shown as we're unmerging, we're identifying proposed lot A as a certain compilation of what's shown on the subdivision plan. Lot B is a proposed compilation, and lot C is really what we're seeking the variance for. That's really all that we're looking for is lot C.
And has any perk test been done to see where our groundwater is there for these lots as we would be making them buildable? Has anything been looked at for a number of bedrooms and such?
No, not at all. This is the first step to my knowledge.
Okay.
So, question, Mr. Chairman, to address Mr. Christopher's concerns, is that part of the building permit?
If I might jump in, Mr. Pennard, I think we would be, although the driveways could have been constructed back in 1980, all the way up until 85 along Race Lane, I think we would be willing to not have any curb cuts and maybe have that as a condition in this grant of a variance, if that would make the board comfortable. No curb cuts off of Race Lane or Old Mill. So on that particular corner that Chris was referencing to address that concern, we would have no curb cut off of Old Mill or Race Lane.
So, because Paul, to your concern, because it'd be single family residential zoning, it would not go to site plan review for that sort of look like as a commercial or larger development would, where that gets looked at more closely.
Right. So Mr. Christopher
wouldn't weigh in.
So Mr. Christopher, if there was a stipulation here for no driveways entering Race Lane, would that satisfy your concern?
Yes. For Race Lane, absolutely. For Old Mill, absolutely, yes.
Okay, thank you.
Thank you, Paul.
Anyone else from the public here to speak to this? Looks like we've got 2 or 3 other people here. You just want to unmute yourself. iPad?
Yes, can you hear me okay?
Yep, just say your name and address for the record, please.
Yeah, thank you. My name is Dave Moore and I live on Mill Race Road. I have the opposite view of Christopher. So I look at it from the end of my driveway towards that end of the property.
Are you 20 then? Is that your address?
Correct. Okay, my question is, I also was a bit concerned with the ingress egress. So what becomes less of a problem on Race Lane becomes more of a problem for me. So, but I understand for proper use, my real concern is the property going to continue to be single-family housing? So in other words, there'll be 3 single-family house on a reconstituted property.
That is correct. If I might jump in, Mr. Chair.
Yep. Okay. And I would expect then that may suggest that the look and the price range would be in conformance with other houses in the area.
That's correct.
Yeah, we can hope that, but we could add a condition of something like that. You know, again, that'll be the direct discretion of the board. But
Yeah.
if we were to approve this, it would be just single family would be the biggest restriction, and other bulk regulations for that area.
Yeah. Okay. Because the value of the homes, I mean, those are easily attainable with the town records.
Mhm.
So yeah, that was the extent of my concerns. Thank you so much.
Thank you. Anyone else from the public here to speak to this? Looks like there's 1 or 2 other people maybe. R. Finucio, if you want to speak to this, just unmute and ask there. Yep. R.
Sure.
Finucio, just name and address.
Sure. My name is Rick Finuccio. I'm actually one of the owners of this subject property and represented by Attorney Schultz. So I don't have any questions, of course, as one of the applicants here. Thank you.
Thank you. Theory, if you'd like to speak. Oh, yeah, go ahead.
I don't have any questions or concerns. I'm just
Thank you.
listening in.
All right, I'll make a motion to close public comment.
Second, Mark.
Roll call vote. Denise Johnson,
In favor.
Barb Bodenstein,
I'm in favor.
Mark Hanson,
In favor.
Paul Pinard,
In favor.
and I'm also in favor. So that closes public comment. Does anyone have any thoughts or concerns or want to think about any conditions or anything of that nature?
Just a thought, Mr. Chairman, and again, I'm really not directing it towards this, but it's something that you know, these mergers are coming up a little more frequently, where you know we've hit that point where they are merged and we're unmerging them to create we're creating value by by giving a variance for this type of property. I always think it's worth asking, if that's the case, and if it's not something by right, and if it is going to be sold or developed and sold, would the petitioner ever be open to the idea? I'm not trying to limit the question, but are petitioners open to the idea of making any sort of donations towards affordable housing trusts or something of that nature? Again, I don't know what the particular, it hasn't been really said what the particular nature of this particular, merger is or unmerging. But it's just a thought as these come forward.
Yeah, I mean, it's clear that the applicant purchased the property knowing the zoning constraints attached to it. And so I assume they purchased the property knowing, hey, we can build 2 houses here. So we would be giving a bonus density. And yeah, again, that's where, as we struggle with this affordable housing puzzle, and there are different inclusionary ordinances that do involve different subdivision stuff and things like that. And that's where I was sort of trying to figure out, is there a way? I mean, and again, I guess if they wanted to, I don't know if the 40B.
And if I might, Mr. Chair, just
go ahead.
Just jumping in real quick, I think the density of what variances would be sought would be, if there were an affordable component to it, because it would have been much higher. So the division would have been, rather than 3 lots, it may have been 6 lots, right?
I'm not saying I'm sorry to jump in there. I'm not saying add an affordable component to it. I'm saying I understand that they may do that, but we're creating value here. So if they do want to do that, if it is being developed for sale, that it, could there be something there where, there was a donation made, or a percentage, small maybe, or something where we're struggling here with affordable housing. We don't necessarily need to deed this and make it more difficult for the petitioner, but again, we are creating value here where it doesn't exist. And I just want it to be in the back of the board's mind when we make decisions like this moving forward, because they seem to be, we have had a few situations where we have unlocked land that previously would not be locked.
I think that's a good idea, but I also suggest that that's the purview of the town council.
I understand.
Because it's rather than our board.
I understand.
If I could interject as the owner, I as a local architect, I've been involved in housing for 35, 40 plus years on Cape Cod. I've worked on hundreds and hundreds of market rate and affordable housing communities. So I believe in what the town is trying to do. I think we've got a good housing production plan. I don't believe my partners and I would be opposed to the idea of some level of donation. But as Mr. Schultz pointed out, because this is only 3 lots, I don't know how we put a formula to that. But I just would put that forward that if the board were inclined to grant the variance, that we would give serious consideration to making some level of donation to the Affordable Housing Trust. Thank you.
Thank you.
I mean, I appreciate you even putting that forward. And again, I wanted to say that I'm not trying to necessarily put it on this, and I don't want to necessarily put any deed on this, but I think it's something where, and I'm coming from this from someone that, is attempting to develop housing, and I get it that we try to give back in whatever ways possible, but it's still a business. It's still things that we do. I don't want to inhibit this property in any way, but I just wanted to have it come up as because this is happening more frequently, and we would appreciate, obviously.
Yeah.
Mr. Chairman, I make a motion that we bring this back to the board, close public comment.
I think we did. Did we
We
do
already
that?
closed.
I lose my mind.
All right, then I make a motion that we vote on this.
Okay. Just remember, guys, this is a variance, so we need to make sure that we've, passed the 3-prong test here and just cover that if someone would like to make findings.
Oh, are you asking to make findings?
I'm throwing it back out there. Again, it's a variance, so we have to, have our 3 prongs here, and just make sure we can cover this. And Attorney Schultz did give us some pointers in his memo.
Yeah, I'm looking at it.
I think we just have to decide if we agree or feel comfortable with those.
Well, let me see here. Well, clearly, there's a topography here. Second, I would say there'd be a financial hardship because you wouldn't be able to build on that lot. I mean, it would be empty land.
Yeah, I think
we can build on 2 lots, not 3.
That's right. And third, I think it raises the value of property all around it, as we heard that it's all built out on far less than 2-acre lots. So I think it would be not detrimental to public good, but substantially beneficial to the public good.
And the fact that it's surrounded by the 4 roads really makes it impossible for them to purchase any additional land, otherwise, which would make that conforming. I think that alone makes it just the shape and the fact that it is bound on all 4 sides.
So do we feel comfortable with conditions? I heard Paul talk to Christopher regarding road access from only one side possibly, or from just the side roads there. And then there was also some discussion over size and scale of the surrounding homes. Do we want to make conditions on there that would speak to that? Is that something that?
Yeah, I would suggest, Mr. Chairman, 2 conditions. One, as we discussed with respect to access, egress, driveways to the 3 proposed lots would not be on Race Lane or Old Mill Road. And secondly, I would say that if we approve this variance, then it's conditional upon the other two lots being formed, if that makes sense.
Yeah, basically,
Well,
as it's proposed, all three are created.
Precisely.
Okay.
Mr.
Attorney
Chair,
Schultz, are you
just
comfortable with that? Is your client comfortable with that, with those conditions if we get there?
Rick, would you like to go ahead and answer?
Those two conditions as presented would be acceptable to us, yes.
Okay, good.
So, Paul, do you want to just, make findings, basically kind of what you went through there?
Yeah, why did I earn this one, Jay?
I think so.
Okay, this has to do with appeal number 2022-051, Schultz, trustee of Race Mill Realty Trust. Michael F. Schultz, trustee of Race Mill Realty Trust, has positioned for a variance pursuant to section 240-14E, bulk regulations footnote 2. The petitioner proposes a subdivision of land where a parcel has a proposed lot area of 72,600 square feet, where 87,120 square feet is required. The subject properties are addressed as 7 Millrace Road, 1479 Race Lane, 1465 Race Lane, 1451 Race Lane, 1437 Race Lane, 12 Old Mill Road, 6 Elmwood Drive, 20 Elmwood Drive, 34 Elmwood Drive, 27 Camelback Road, 11 Camelback Road, as shown on the Assessor's Map 064 as parcels 071, 072, 073, 074, 075, 076, 077, 094, 095, 096, and 097. The lots are located in the residential F zoning district, RF zoning district. I find that owing to the circumstances related to the topography, the shape of the lot under question, because it is bounded on 3 sides by roads, which makes it impossible to expand because it would throw the adjoining lot into non-conformance, that this should be granted. I find that a literal enforcement of the provisions of the zoning ordinance would involve substantial hardship, which is financial hardship to the petitioner. And that being that if this cannot be formed, if the variance is not granted, then we have one less building lot and only 2 remaining. And that's definitely a financial hardship here. I find that desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent and purpose of the zoning ordinance. I find that, in fact, it is beneficial to the public good because it will allow for 3 homes, or excuse me, in this case, 1 home on what would be vacant land. Those are my findings.
Thank you, Paul. Do I have a second to approve Paul's findings?
Second, Mark Hansen.
And a roll call vote. Denise Johnson.
Favor.
Herb Bodenseek.
In favor.
Mark Hansen.
I'm in favor.
Paul Pinard.
In favor.
And I am also in favor. Paul, can you bring us some suggested conditions? Or some
yes, I am noting conditions 1 through 5 as noted by staff findings of some date. Somebody help me out here.
October 6th.
October 6th, 2022. I would like to add condition 6, which would be that there would be no egress or access to the 3 proposed lots from Race Lane or Old Mill Road. Number 7, that this approval is contingent on the other 2 parcels being formed, so that in fact there are 3 parcels, 2 are conforming, and this one variance, if granted, would be non-conforming. Those are the 7. Are those okay with you, Attorney Schultz?
Did you want to add, or is the board want to add number 8, that the size and scale of the homes match within reason the surrounding neighborhood? Or do we not want to put that on there?
Well, but the surrounding neighborhood is not 2-acre lots. I would hope that these are going to be much bigger.
Again, that's for discussion here. It's something that came
I
up.
think that's too subjective. I don't know. I wouldn't want to put that.
Yeah,
Herb Bonesig, I agree. It's too restrictive.
Okay. All right, so we'll stick with the 7 as read. Roll call vote. Herb Bonesig.
In favor.
Denise Johnson.
Favor.
Paul Bernard.
In favor.
Mark Hanson.
I'm in favor.
And I'm also in favor. So you guys have your variance.
Members of the board, thank you very much.
Thank you.
Thank you for your time.
Yeah, sorry you had to wait 2.5 hours.
Yeah, sorry to wait all night.
Thanks for sitting through this.
I live in West Barnstable. I actually appreciated listening in. Thank you.
Excellent.
It was interesting.
Thank you.
Thank you again.
Thank you.
Thanks for your time.
All right.
Thank you.
Correspondence. Anna, thank you for forwarding out the training stuff. I don't think there was anything else unless I missed something.
No, I think that was it.
Okay.
And matters not reasonably anticipated, the 2020 schedule.
Yeah. And also, I didn't introduce Counselor Clark is our liaison now. I don't know if she's still here and awake at this. We're chasing town council night time here.
She's probably not going to do it anymore.
Thank you, Counselor Clark, and
I am here.
having you around and working with us and bringing us, anything that comes your way that we can do better.
Thank you for your good work. Thank you.
We brought you an entertaining one tonight. Sorry it went on so long, but it was a heavy one to lift tonight.
That's the work we appreciate the work of our volunteer committee members. Thank you.
Thank you.
You mean we're not getting paid?
There are over 40 committees, and you're a heavy lift. Thank you very much.
Thank you. So does anyone have any comments now on the schedule? I mean, you can send email to Anna if there's any comments on that 2023 schedule.
It looked pretty straightforward. Christmas and Thanksgiving are the only interfering holidays.
Yep. Is there any more thoughts? And I'll sorry, go ahead, Denise.
Are these going to be in person, or is it going to be like a mixture?
That was going to be my next question. I also was going to direct it to Counselor Clark and sort of get her opinion from the town council level. I had sort of presented this idea a few months ago that our first meeting of the month is in person and our second one is online, so that if there's people that really would like to present in person, they have the opportunity to schedule it to one of our in-person meetings. And if there's something that has a lot of public comment or something, if we feel it's necessary or a public comment says, hey, there's a lot of people out there that want to speak to this, we can continue it so we get both meetings and we hear from both sides of the public.
Yeah. I can't add anything to this at this point. It's a technical town of Barnstable maneuvering, so I leave it up to you.
Okay. What is the council doing going forward? I know you guys are online the rest of the year. What happens after January?
The primary reason we're on Zoom is because because of election, and that there is early voting at the town hall, and that the town council can't meet in the meeting room because it has been secured for ballots and elections. So at this time, that's my best understanding.
Hey, Herb Bonesig, I have a question. So I live off Finney's Lane, and I was going to come in and rant and rave about, obviously, everybody knows that issue. So I guess if it's not in person, I'm not going to bother.
What do you mean, rant and rave?
So I think we all know what that means.
No, you mean public comment?
I have concerns, but I think town council meeting might be better for that.
Yes, that town councilor, send a letter to your town councilor or to the entire town council.
There you go.
All right, so next thing we have to elect a vice chair. So I ask for nominations from the floor for a vice chair, or we can discuss. I didn't have an opportunity to speak to anyone on the phone. Does anyone want to make a nomination or have a desire to step up to be?
I'd like to nominate Herb if he'll take it.
Oh, thank you, Paul.
Do we have any other nominations from the floor? All right, I will declare nominations closed and we take a vote on making Herb our vice chair. Aaron Webb?
I'm in favor of Herb.
Thank you.
Paul Pinard?
Yeah, I like Herb.
Mark Hanson? Denise Johnson?
Even if you don't like me.
Herb
Thank you,
Bonesy?
guys.
And I also am in favor of making Herb vice chair. Now, Anna, tell me, do we need to now make a new clerk?
Yes.
Okay. So
Please.
now I'm on the floor for a clerk.
Herb's
I would like to nominate Paul.
There you go.
All right. Are there any more nominations from the floor? Seeing none, I will declare nominations closed and we'll take a roll call vote on making Paul Pinard our clerk. Herb Bonesy.
Oh, I didn't know his last name was Bernard. I might have to reconsider. No, I don't know.
I don't know if this is a promotion.
I don't even know if that.
Aaron Webb.
I'm in favor of the demotion.
Denise Johnson.
Favor.
Mark Hanson.
In favor.
And Paul Pinard.
Oh, yeah, oh, sure.
And I'm also in favor. So we have our board. Upcoming hearings, November 9th, December 7th, both are online. Anna, are there anything we should know? Are these busy schedules?
No, they're pretty small.
And as a counselor, I thank you for your volunteer service.
Well, thank you for sticking with us until 10:12 at night.
And we thank you as well. We know you don't make a lot of money out of this yourself, so it's almost a volunteer position for you.
Appreciate that.
We appreciate it.
Looking forward to our new relationship. Thank you.
Thank you.
I'll take a motion to adjourn.
So moved.
And a second.
I'll second that.
All right, roll call vote. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Mark Hanson.
In favor.
Aaron Webb.
In favor.
Denise Johnson.
Favor.
And I am also in favor. So we are adjourned. David at Channel 18, thank you for sticking with us